Good afternoon, everyone. I'm going to turn it over to the clerk for a roll call.
And members can please vote using their electronic voting system.
Madam Clerk, I just got a text message that says there's no audio.
Mr. Chair, I'll call the names of those who haven't registered their presence. If you would please unmute and indicate your presence. Delegate Corey. I can't hear. Delegate.
Yes. Yes, here.
He's there. Delegate Corey, I see you. Delegate Wright, we see you. Delegate Wilt, we have seen you. Delegate Ferris. And Delegate Campbell.
Cheryl, Delegate Ferris is trying to get in using a phone number and he is unable to get in.
Mr. Chair, a quorum is present.
Great. Thank you, Madam Clerk. Let's go ahead and get started. We have a few administrative procedures before we get into any of the bills. Administrative referral to appropriations, and this is by voice vote. House Bill 5017, Delegate Weber. House Bill 5032, Delegate Miyares. And House Bill 5034, also Delegate Miyares. This is just a voice vote. All in favor, say aye.
Aye.
Aye. Opposed? All right, those three bills are referred to appropriations. Next item on the agenda is also administrative, and this is a bill to lay the bill on the table and send a letter to the FOIA Council. This is House Bill 5092, Delegate Rush's bill. Delegate Rush, before I entertain a motion to lay your bill on the table, do you want to describe your bill? One of the things that we realized as we were preparing for this meeting is that your bill is largely a general laws topic and is a FOIA issue. Since general laws is already met, instead of us giving it I'd rather give it an opportunity, in other words, to come back in 2021. And so the recommendation will be to lay the bill on the table. Delegate Rush, do you want to speak to your bill before we consider that motion?
Well, thank you, Mr. Chairman. I would hope we would act on the bill today. This is a transparency issue. It allows the board's votes to be available to the public, which I think is probably an oversight back in the very beginning of this whole process. And since parole has really sped up over the last couple of years, I think it's more than fair for our constituents and the citizens of Virginia to know how the parole board has what the vote is and have some transparency in this whole process. So I hope we'd act on it today, but you're running the show, so go ahead, Mr. Chairman.
Thank you, Delegate Rush. It's more appropriate to put this into the General Laws Committee, and I think just rather than doing that because they've already met, that would seal the fate. And so I think this is a better outcome. So what I will do is after we lay the bill on the table, I will send a letter to the FOIA Council to ask them to take this up in this off season so that we can have a recommendation for 2021. So can I get a motion to lay the bill on the table?
Motion to lay it on the table.
Got a motion, properly second?
Second.
All in favor, say aye. Oh,
Aye.
that's a voice.
Aye.
Sorry, this is a vote, a recorded vote. So please vote on your iPad. Lay the bill on the table. Vote aye. No. Yeah. Why don't we have the clerk call the names of people who haven't voted?
Delegate Corey.
Muted.
Delegate Corey. Delegate Wilt.
No.
Delegate Wilt votes no. Delegate Ferris.
I vote yes.
Ferris is no.
Delegate Ferris votes no. Delegate Campbell.
It does let go whenever.
And if I could go back, please, Delegate Corey. Delegate Corey. Aye. Mr. Chair, there are 13 yeas, 9 nays.
Okay. All right, the next bills before us are three bills I want to call up at the same time because we have three bills that are very similar. Before we get started, though, I do appreciate everyone being flexible, especially during these extraordinary times. Hopefully, I'd love to see everyone in person, but hopefully we do get to that point at some point. But we do have to keep our business running. So I'd ask you to be flexible when we try to make sure that we can meet virtually and be successful doing so. The three bills that I want to bring up at the same time because they're very similar and I want to give the patrons an opportunity to explain their bill is House Bill 5007 by Delegate Cole, House Bill 5010 by Delegate Adams, and House Bill 5039 by Delegate O'Quinn. So if we can make sure that they're in the meeting and they can, and I'll start with Delegate Cole, since he has the lower number, House Bill 5007, to present the bill. And if Delegates Adam or Delegate O'Quinn want to add anything, they're certainly welcome to do so. Delegate Cole?
And Mr. Chair, I believe that we are just bringing them into the room now.
Thank you.
Thank you.
This is Delegate.
We can hear you, Delegate Cole. Would you present your bill? And if you heard what I was doing, I'm bringing the three bills that are very similar, and I'd like you to describe the bill, and Delegates O'Quinn and Delegate Adam can add any color, if anything, that you've missed in presenting the bill. Delegate Cole, you're recognized.
Yeah, basically, just real briefly, my bill does two things. One, it limits the duration of an emergency order declared by the governor to 30 days. In order to extend the emergency beyond 30 days, the legislature would have to convene and pass a resolution basically extending the emergency beyond 30 days. And the other thing it does is it deals with the penalty for disobeying an emergency order. It makes it a civil penalty instead of a criminal penalty. It limits it to a $100 civil fine and a cumulative of not more than $1,000 for the same offense. And that's basically it in a nutshell. I think the current law is too broad. Like right now, the governor, his emergency orders don't expire until next June, the end of next June, and there's nothing in the code that prevents him from, at that time, turning around and declaring an emergency and reinstituting it all on July 1st without any input from the legislature. And I think whether it's 30 days, 60 days, or whatever, there needs to be, I think, a more effective limit on the governor's emergency powers. And that's
Great.
basically the bill.
Thank you, Delegate Cole. Do either Delegates Adam or Quinn, do you want to add anything to the presentation of the bill?
This is Delegate Adams. Can you hear me?
Delegate Adams, you're recognized.
Right. Okay. Looks like the video is not working here, but the bill that I have introduced, it changes only one thing with the emergency powers, and that is it places a 60-day limit if not approved by the General Assembly on executive orders issued pursuant to the Emergency Services and Disaster Law. And so similar to the reasoning behind Delegate Cole's bill, 60 days I thought was a time in looking, at least with this past experience that we have here, of any services that the governor would order, that is plenty of time to effectuate before a General Assembly could be called back into session. And of course, we know under the Constitution, the governor can call the Assembly back into session for that purpose. The General Assembly can also, by supermajority, call itself back into session. But when you look at the purpose of the Emergency Services and Disaster Law, you read earlier in the chapter, it says that the findings of the General Assembly, because of the ever-present possibility of the occurrence of disasters of unprecedented size and destructiveness resulting from enemy attack, sabotage, or other hostile action, resource shortage, or from fire, flood, earthquake, or other natural disasters. And it goes on like that. And it does include to protect the public's peace, health, and safety. And so, I read some of that to you because it is essential to our government, our way of government, that policy is made by the people's representatives, not by the executive branch, but that there is this special designation in the law for emergency situations where we vest the governor with certain powers to protect the well-being and prosperity, it says in the code, of the governor, or excuse me, of the people, in the face of impending immediate disaster, an irrevocable disaster. And so, I think that is a power that the executive should have, but it should not be unlimited. As we know, the governor in invoking his executive authority, declaring a disaster, and again, there's no check on the governor. If the governor declares a disaster, he then invokes these powers. And so that is strong power, and not that he shouldn't have it, but it shouldn't be infinite, shouldn't be unlimited. And we know that the governor himself limited his own time frame in his underlying orders initially. But as time went on, he amended his initial declarations and removed any self-imposed limitation. And so the only limitation is basically, after the following regular session. So we're talking about a year before any policymakers can weigh in on the multiple policy decisions that have been issued by the executive. And so I know of no reason why the General Assembly could not weigh in on something after 60, how that would interfere with the purposes of the disaster law. But we have people, we all have constituents calling saying, how can this happen? How can the governor enact this and the people's representatives not have a say? Well, this legislation would allow us to have a say, and if the people's representatives endorsed the policy decisions that the governor made under his executive authority, then it could continue. But I think this is a scenario that ought to invoke some bipartisan support, because we're talking about the checks and balances of the different branches of government, not a partisan question, in my view. And so I hope that that this committee will look favorable on this type of legislation. And if it's not 60 days, that maybe it be something else. But 60 days seem to be a reasonable amount of time based on this past experience.
Thank you, Delegate Adams. Delegate O'Quinn, did you have anything you wanted to add?
Yeah, thank you, Mr. Chairman. So I think Delegate Adams hit a lot of the things that I would have said on my bill. And of course, my bill is a little different than some of the others. Mine authorizes 45 days and then an additional 45 days after that. So for basically a grand total of approximately 3 months. And I too believe that we have three branches of government for a reason. It's checks and balances and separation of powers. And what I've seen in across a lot of states, and our state, our company does business in 5 states, and I've seen Republican and Democrat governors, along with a combination of Republican and Democrat legislatures, grapple with this issue of just how much authority should a governor have. And what you end up with, I think, in these protracted states of emergency is a situation where governors end up making a lot of laws, and that is not their job. And that should concern every single one of us. And whether you think the governor's done a great job or a terrible job or somewhere in between is totally inconsequential to this discussion. Just think for a moment about someone in the opposite party that you do not like and you do not agree with having this much authority. And one of these days, that's going to end up being what happens, because the pendulum always swings back the other way, and we're going to fool around and have a situation where we are in a real dire situation with high stake consequences and a governor with completely unfettered ability. And I do think a governor should be able to call a state of emergency. Absolutely believe that, and this bill does not mess with that. But I do think that the General Assembly should have an opportunity to convene and weigh in on essentially laws that are being made in our absence. And that's pretty much my bill and why I filed it.
Thank you, Delegate O'Quinn. Before I turn to the public testimony, looking for questions from the members. Delegate Coiner, do you have a question? See your hand up.
Yes, Mr. Chair, I had a question. My hand was raised prior to them starting. It does not have to do with these bills. It was a point of information. I can wait until you're done with this block if that's better.
I'm sorry, what was your question?
My hand was raised before the bills started to be heard. It was a point of information about the public participation. I can wait until you're done with this block and then ask it. Whatever you prefer.
Let's do that after. We'll do that after the bill. Thank you, Delegate Coiner. All right, so I'm going to turn to not seeing any other questions from the members. I'm going to turn to the public. Yes. Oh. Okay, so we have no one in the room waiting to testify to these three bills. So, Delegate Levine, you're recognized.
Thank you, Mr. Chairman. Speaking to these three measures.
You're recognized.
This is designed for an emergency. If you look at the code section that all three bills are trying to change, it deals with some pretty extreme situations, things like disasters, things like requiring a mandatory evacuation, things like a public health emergency, which we are in right now. We are not a full-time legislature. Maybe we should be. That's a question for another day. Maybe we should amend our constitution, and many states have full-time legislators. We are not. We, except for a special session, can go out for 10 months, 11 months on end. It requires the governor to come back every 30 days, every 45 days, even every 90 days, and consult the legislature, particularly in the current example. It's a great example of why we need this law to stay the same as it is, because in COVID, this isn't going away in 45 days or 90 days. I hope it will be beyond us in a year. I'm not sure it will be. I do worry, Delegate O'Quinn is right. I do worry about our powers, separation of powers. I do worry about a runaway executive. I know the President of the United States declared an emergency to build a wall. I don't think there's any emergency there at all. And I think that should and has been challenged in the courts. And frankly, you know, if there's no real emergency, which is really what we're talking about, where there's no real emergency, the governor actions can be challenged. But if we have a runaway governor, under our Constitution, 2/3 of us can vote to go into session without the governor, and 2/3 of us can vote to overrule anything the governor does. So if we have a runaway governor doing things that are crazy and are not related to an emergency, we have the power to step in. That's an emergency break. I have not seen abuse here, and I think this is designed for an emergency, and I think it's been appropriately used. So I urge us all to vote against these bills. Thank you.
Thank you, Delegate Levine. I'm told that someone from the governor's office, Rita Davis, wants to testify. Ms. Davis, are you available?
I am, Mr. Chair. Thank you very much. Members of the committee, I'm Rita Davis, counsel to the governor. Can you hear me?
Yes, Ms. Davis, you're recognized. Welcome.
Thank you. These three bills present numerous problems for the administration, and the governor strongly urges you not to report these bills out. The language in the bills are dangerous and pose a constraint on the executive's ability to assess and to respond and to mitigate emergent threats. But all threats to public health and safety arrive in the form of turbulent winds or flooding rains or fast-moving funnel clouds. Some take the form of persistent, indiscriminate, aggressive, microscopic, yet virulent organisms that linger in the air and the surface and invade the body to cause severe injury and sometimes death. The chief executive, as that power is invested in him by the Constitution, needs the ability to react quickly and flexibly and decisively in combating any threat that poses itself to the Commonwealth of Virginia. The language in these bills prevent the governor the one person passed by both the Constitution and the Code of Virginia from protecting the lives of Virginians during an emergency. And Mr. Chair, I would like to also respond to a comment that was made that under the current laws of Virginia, the governor's power seems quote unquote unlimited. I think the administration would disagree with that, hence the need for this special session. The governor has recognized that there are numerous things, numerous policy issues that needed to be decided relevant to the COVID-19 pandemic, and that the best body to make those decisions is the General Assembly. Hence is why he asked you guys to come back and do that. So I think the administration would say the governor recognizes that his power is not unlimited, and that setting policies in the purview of the General Assembly. All that said, Mr. Chair, the administration strongly opposes the reporting of this bill. Thank you.
Thank you, Ms. Davis. Delegate Davis, you're recognized.
Thank you, Mr. Chairman. Mr. Chairman, I appreciate the aforementioned comments, and I agree that the governor needs the ability to respond quickly. That's what these orders are there for. But we're not talking about limiting the governor's ability to respond to anything. We're not talking about he's got to wait 45 days before he can put an emergency order in place. We're talking about limiting the time frame that emergency order can go for. So we're not talking about anything that will limit a governor's ability to say we need to react, we need to act quickly and now because it's an emergency. What we're talking about is how long should that order go for? And Mr. Chairman, this is just talking about good policy. It doesn't matter who's the governor today. As far as I can care, it could be a Republican governor. There still should be a limit of time, much less than June of next year, that an executive order should last for. I appreciate the other delegates' comment of 2/3 of us could vote to put us back in the session. I'm not quite sure how we vote to do that if we're not there to begin with, but that's beside the point. But the fact of the matter is there are some rules in place that protect minority opinion. A wise man once said, just because the minority loses doesn't mean the minority is always wrong. There should be some point in time that's reasonable. 30, 45, 60 days. We have 3 delegates, I believe, on our side with 3 different time frames that are given 3 different opinions of how long a governor's executive order should go for before we have to come back in the session and authorize it. And Mr. Chairman, I'm willing to listen to your side. If you want to make it 60, 75, 80, I think if we can't all agree that it should be shorter than next June, we have a big problem. But I just can't find a bill from the Democrats either that put a limit on this. And I'm kind of surprised I can't, because this could be a Republican governor. And I'm pretty sure at that point, y'all would be putting these bills in.
Thank you. Thank you, Delegate Davis. Any other member wish to be recognized? Committee works on motion.
I move to pass.
Got a motion to report.
Substitute motion to table the bills, all 3 bills in block.
Delegate Levine makes a superior motion to table the bills.
Second.
Properly second is not debatable. Please vote to lay the bills on the table on your electronic voting device. I'll ask the clerk to call the roll for the remaining who haven't voted.
Delegate Wilt.
Delegate Wilt votes no.
Delegate Wilt votes no. Delegate Ferris.
No. No. Delegate Ferris is a no.
Delegate Ferris votes no. Mr. Chair, all members have voted 13-9.
Good. The bill is laid on the table 13-9. All right. The next bill, and I want to turn to Delegate Coiner, who had a question about witnesses coming in. Is that right, Delegate Coiner?
Yes, thank you, Mr. Chair. I had a few constituents who were asking, first of all, who Sharon was, because I guess that's who they're going through in order to get into the meeting. And then second, just for our benefit, this is my first committee meeting this session, how the public is let in and how you all know which bills they're speaking to.
Do you want to explain? Yes.
Thank you.
I can help with that. When the public notice for a committee meeting is issued, at that time, the speaking queue is turned on. Members of the public, lobbyists, anyone can register to speak. They indicate when they're registering to speak which bill they'd like to testify on and whether they're for or against. That speaking queue is turned off about an hour before the meeting begins, and the members who have signed up, those who have signed up, receive a Zoom invitation to a separate Zoom meeting. As that bill is called up, those who clicked on the link and joined this separate Zoom meeting are brought into the room. And that's why you hear us say that they're brought into the room so that they can then testify to you. Sometimes people who receive the link don't activate it or log on, and a few times we don't know until we call their name. But Mr. Chair, that's in a nutshell how the public testimony process works.
Thank you, Madam Clerk. This is going to work very similar to the way we had the committees, the joint committees, those 3 hearings that we had. It's going to be very similar to that. All right, so let me go ahead and call the next bill up, House Bill 5043, Delegate Bourne's bill. And we do have, I should say, we do have a number of people that have signed up both for and against this piece of legislation. And once Delegate Bourne presents his bill, we'll go out to the members to see if they have any questions for the patron. What I will do at that time is I'll put a 10-minute limit on the witnesses to speak in favor and a 10-minute time limit on those to speak in opposition. So with that, Delegate Bourne.
Thank you, Mr. Chairman. Hopefully the audio is working good. And I believe you and I have talked about a substitute, and I don't know whether Charles has prepared that or not. So it may be best to get that substitute before us before we go into the bill.
Why don't we go ahead and do that? And we can explain the substitute. Charles, do you want to explain the substitute?
Mr. Chair, I thought I was confused a little bit in that I thought the substitute may have been discussed and seeing the will of the committee, but essentially the substitute would relocate these provisions to 37.2, if I understood correctly. That was the intended substitute. And I thought that the committee would debate if we thought that was an appropriate substitute. So,
well, the patron, what do you want to do, Delegate?
I think it is the right thing to do. So I would prefer that as a substitute rather than. We have a motion. I would move that. I'd move that the committee adopt the substitute as presented by Charles, and it does not change any of the words of the bill. It's simply the numbers in the code section where it will go.
Without objection, substitute is adopted before us.
Right. Thank you, Mr. Chairman. Yes, House Bill 543 is going to be referred to as the Marcus David Peters Act. And long story short, it creates community care teams. And the bill was born out of a tragedy that happened a couple years ago where Marcus David Peters was fatally shot by Richmond City Police. And unfortunately, Marcus David Peters was having a severe mental health crisis during the time in which the incident began. And so out of that, his family, a wealth and host of community advocates and stakeholders came together and really started developing what's known as the Marcus Alert System, which this bill hopefully will create. And this creates community care teams that are going to respond when law enforcement is called or respond to individuals who are having mental health crises. These teams are going to be made up of mental health professionals, certified peer recovery specialists, law enforcement, if they're on the scene, mental health professional is going to absolutely take the lead in these situations because what we found and what we know intuitively is that in lots of cases, the mere presence or sight of a uniform or a police vehicle can further exacerbate or further amplify the mental health crisis. The bill requires Department of Behavioral Health and DCJS to work together to create really evidence-based training programs for these care teams so that they have the requisite training and know-how to really know how to effectively address and mitigate and de-escalate these situations. And hopefully the law will help ensure that people having mental health crises are met with the appropriate resources and supports, and not just being locked up or put in jail or put in the back of a cruiser. And so that's really what this bill seeks to do. And so I'd be happy to answer any questions the committee might have.
Thank you, Delegate Bourne. Delegate Davis, you're recognized.
Thank you, Mr. Chairman. Mr. Chairman, can you please tell the committee again where we can find the substitute at?
Charles.
Mr. Chairman, I would say to the delegate that as Charles, I thought pretty plainly explained, there was some confusion about whether to adopt or to draft the substitute prior to or after the committee debate. However, having slept on it for a day or two, I believe putting this bill in the healthcare mental health section of the code rather than the DCJS code is more appropriate, because the end goal of this is to really address mental health crisis when they're interacting or when they might be interacting with law enforcement. And so there is a more practical and reason to put it in that section of the code rather than 9.1.
Further question, Mr. Chairman?
Delegate Davis.
And Delegate, I was paying attention earlier when staff was sharing something. I was a little bit confused, and I figured I would ask my question after in case it actually helped clarify it for me. But the bill in front of us now, it's not just that we're going to put that into a different section of code, but it actually, what you're attempting to do is completely different language than the bill in front of us today, correct?
No. The words, the substance, the teams, nothing will change other than the code sections.
Mr. Chairman.
Okay.
Thank you, Delegate Davis. Delegate Coiner.
Thank you, Mr. Chair. I have a question for Delegate Bourne.
You're recognized.
Thank you, Mr. Chair. So as I read the proposed language, it reads to me that if law enforcement is contacted for a person experiencing mental illness or substance abuse problems, then it mandates that the community care team is who must respond first to that call. Is that correct?
I think in a perfect ideal situation, yes, but we often know that 911 calls come in, and so once that team is assembled there, the mental health crisis, if it's that situation, the mental health professionals will take the lead, and the law enforcement there is purely a support and backup to protect anyone who might be around. But the idea is to get the mental health folks there taking the lead on the interactions and trying to de-escalate the situation.
Mr. Chair, a follow-up question?
Delegate Coiner.
So, I am all for having mental health professionals assist in situations. I think some of our localities have done a really good job of putting these together on their own. My concern comes when we do have victims or potential victims who will be impacted by someone experiencing a mental health crisis or substance abuse, and whether, because of how narrow, and it says that they shall respond, and to me it reads that they must be first, whether this puts our law enforcement in a situation of waiting when victims could be harmed. And so I guess I'm supportive in concept. I'm struggling, having personally gone through an experience with someone who was under the use of drugs and came after a family member with a knife and calling 911, and the response on the phone was, they're using a drug and they're coming after me, come help. Whether or not this requires the pause because they've said someone is using a substance and assembling a team to respond. I know it's not your intent, but it's the way I read it from a legal perspective. So that's my concern.
Well, Mr. Chairman, I would respond to Delegate Coiner by saying, from a legal perspective, I think officers and law enforcement are under a duty to protect people. And if the call came in, as you've expressed your example, my understanding is law enforcement has an absolute overarching duty to protect people. And so given the facts and circumstances of that particular example, protection of the people who are being victimized would necessitate them going in first. But obviously the mental health care people would be there help address the substance abuse, the mental health crisis, such that I think it's intended to do.
Delegate Wilt, you recognize.
Thank you, Mr. Chairman. Delegate Bourne, in past line 300 or so there in your bill, talking about the issue of identifying underserved populations and historically, economically disadvantaged communities. So I get the concept that you're promoting here, but help me understand the tie-in with that language. What exactly? Yeah, help me understand how you're carving out a specific community for this to apply to.
And you said line 300, sir?
Yeah, I'm sorry. Yeah, about 313. The definition's a little bit earlier than that, but that's where it's actually used in the body of the bill.
So I think the reasoning behind that, Mr. Chairman, the reason I would answer the delegate by saying that the reasoning behind that is there's a wealth of research out there that suggests that minority communities and poor communities are less likely to get proactive mental health services. And I think one of the reasons that we're in this special session is the stark reality, the unfortunate stark reality that underserved, underprivileged, economically disadvantaged communities of color are negatively and disproportionately impacted by police behavior, good, bad, or indifferent. And so we wanted to make sure that these crisis teams have the appropriate resources, staff, and knowledge about going into these communities, being part of the process, so that we can really help root out the cause and really address the underlying issues. And it's a goal that I support, and I hope others will too.
Thank you. Delegate, you recognize. Delegate Corey, you are recognized. Are you on mute, Delegate Corey? Delegate Corey?
Yes. Can you hear me?
You recognize Delegate Corey.
Thank you. Thank you, Mr. Chair. I have a question and a comment. Delegate Bourne is aware of my concerns about this bill. He may not be completely aware of my enthusiastic support of the concept, however. And it is something that I know has been successful, crisis teams like this in other parts of the country. And I hope that we will implement something like this in Virginia. But I do have a concern. The bill does not include any requirement for language skills in the team, in the crisis team. And I come from a community, and I know many of you do, where there are many languages spoken other than English. And this team needs to be able to communicate with those present at the situation that it is called to take care of. And I would hope, Delegate Bourne, that you would include some language. Actually, I have language that could be an amendment like that in this bill.
Mr. Chairman, I would say to the delegate, I'm absolutely 100% supportive of that concept, because at the end of the day, if the mental health professionals, the community crisis teams can't communicate with the person in crisis, then we're not going to do any good. And so to the extent that Legislative Services, and I have a high degree of confidence in Charles, can draft something that is fine, and you sent me your language, and as long as that works, I'm fine with that, and would consider that a friendly amendment to the bill.
Thank you, Delegate Bourne.
You want to present your amendment? Is it simple enough that or maybe Charles has it? Does Charles have the amendment? Maybe Mr. Quagliato, can you present the amendment? Are you able to do that?
Mr. Chair, I do have an amendment. that was drafted to the bill that was prior to the substitute, but I could read the amendment, and if the committee so likes it, I can incorporate that into the new substitute.
Would you do that?
Basically, the amendment would be at the end of line 341, it would read, such criteria shall include a requirement that each community care team include at least 2 individuals who are fluent in a language or languages other than English that are commonly spoken in the community.
Get someone to move that amendment.
Mr. Chairman?
Delegate Price,
Yes, I had a question about the amendment.
you recognize.
Thank you, Mr. Chairman and Delegate Corey. In other areas of for this committee, when we've talked about public safety measures to include emergency preparedness, there was an actual measurement that was used, and I think also in election law, there's a measurement that was used as to the population size for which of the languages would be mandated with this inclusion. I'm apologetic at the late hour, but is it possible to clarify that even further so that we would not have someone that on the fly had to interpret what common to the area meant, but an actual measurement, 20% of the population, whatever that is, but something more clearly defined so that we would know what we were talking about.
Mr. Chairman, may I respond? Okay. Thank you, Delegate Price. I am totally aware of the definitions that you're talking about, and they affect they deal with percentages within a population speaking whatever language. However, this is slightly different. What I am trying to get at is some language skills that would be appropriate to the population being served, and that is different than the percentages within a total jurisdiction. Some of the crisis teams I know will have a narrower geographical responsibility than an entire, for example, entire Fairfax County, which has certain percentages of languages that are not English, but that is not necessarily particular to a part of the county, which is why, and I'm absolutely willing to change the language, but my intent was not to specify the language, what language it is, or the percentage within the total jurisdiction population. You understand what I'm not being very clear, I feel, but I hope you understand what I'm saying, Delegate Price.
Mr. Chairman. Yes, to be very clear, I have worked on an emergency preparedness bill that was for language access to information. So I am in support, but the feedback from the community members that we will be adding to this response team need to know what we are directing them to do. And so what I'm trying to do is get us to more clear language so that it's clear between what we are saying that they should do and them receiving the directive. And so is there something more specific, and maybe this question is actually for council, is there something more specific that we could do so that the community knows what is expected of them?
Please, go ahead.
Mr. Chair, off the top of my head, I don't have anything more specific in mind. But that is something that I can kind of work on in between now and when the substitute gets published. If the committee would like to have more specific instruction on how to represent what languages are spoken within the community.
Well, let's do this. Let's put this on hold for right now. There's a couple questions for the patron in the queue from members of the committee, and we'll revisit this before we vote on the bill. And after I hear some testimony. Delegate Batten, you are recognized.
Thank you, Mr. Chairman. I just have a question for the patron regarding funding. I am, familiar with the provisions of the bill, and as Delegate Coiner said, there are a number of localities in Virginia that sort of kind of have already implemented this type of response team. But I'm also aware that much like the Commonwealth is, many of our localities throughout Virginia are suffering some serious financial and fiscal hardships due to the pandemic and the economic shutdown. And I am just curious if there's any sort of funding mechanism involved in this that would help localities establish this, or just generally speaking, where the funding for mental health is going to come from. I know at least in my area, we're already the system is really stressed right now. And while they're generally supportive of these sorts of measures, they are very concerned about, again, where the funding would come from. So just curious to know if there's any consideration there or an accompanying budget funding. Thank you.
Delegate.
Yes, Mr. Chairman, I would say to the delegate that certainly representing a city like Richmond, I understand keenly budget constraints and budget stress. What I would say is my understanding is that this is going to, should the committee act favorably, go to appropriations where we will fight for the dollars necessary to get this up and running. Because I do think that this is an important piece to our work here during the special session. So there's not any specific dollars identified right now, but we are having those conversations and we'll continue to have those through the Appropriations Committee process.
Thank you, Delegate Ford. Delegate Ferris, you're recognized. Delegate Ferris? I know Delegate Ferris is on the phone. All right, I'll come back to you, Delegate Ferris. Delegate Robinson. Delegate Robinson?
Yes, sir. Thank you, Mr. Chairman.
Thank you.
I just have a question. My concern is if we put something like this into place, we're going to need a boatload of mental health workers. I mean, that's 24/7, 365 days a year across the entire Commonwealth. And again, my question is where do we get those folks, the funding to pay those, again, in localities? And then even on top of that, you not only have the crisis team out there, but you also have to have the folks in place when they take them to be dealt with. If we're not going to, be able to take them to the jail, or currently when our officers take our TDOs into the hospitals, they may have to be there for 8 hours with that individual until somebody can step up and take over the case from the officers. And I just don't see how we're going to be able to address those things in your bill. If you could maybe touch on some of that, I'd appreciate it.
Well, Mr. Chairman, I would respond to the delegate by saying, at the sake of repeating myself, we're going to go through the Appropriations Committee process. We're going to continue to fight for the dollars. And I firmly believe that that's what important. If it's important, we'll pay for it. I believe it's important. In addition, I think, if communities are already doing it, then it's those communities have figured it out, and our communities are strong and resilient. But without saying too much more, I'm going to continue to work through the Appropriations Committee process and identify funding for this important measure.
Thank you, Delegate Bourne. And I just want to point out to the committee that this is part of STEP Virginia. This really does intensify that. But this is a version of the mental health crisis teams that is part of STEP Virginia that we're trying to implement to reform our mental health system. And so this is a big part of that. And if we don't fund it through this bill, the General Assembly is on record of trying to work towards funding it in the future. So let me turn to those that are here in the public to speak. Again, we do have several people that are here that want to speak, and I want to give 10 minutes on each side.
Mr. Chairman.
Yes, Delegate.
Go ahead. I'm sorry. You finish and I'll talk. Sorry.
I'm going to do 10 minutes for the pro and 10 minutes for the con. Delegate Bourne.
Mr. Chairman, if we might, and I hate to ask people to skip line, but I did have a witness who is Marcus David Peters' sister, and so hopefully we can get her up to testify as at least my initial witness.
Took the words right out of my mouth. Princess Blandy from the Marcus David Peters family, followed by Dominique Martin. Ms. Blandy, welcome.
Yes, sir.
Thank you for being here.
Thank you. Can you all hear me?
Yes, ma'am. Thank you. You're recognized. Thank you for being here.
Thank you, sir. Again, my name is Princess Blandon, and I am the very proud sister of the late Marcus David Peters. Sorry.
Take your time, please.
An amazing Black man, son, brother, uncle, teacher, mentor, VCU alumnus, and more importantly, just an overall amazing human being who was murdered by a Richmond police officer on May 14th, 2018, shortly after Marcus completed a full day of teaching high school biology at Essex High School, where I also served as the assistant principal at. Marcus David Peters was unarmed, completely undressed, and experiencing his very first mental health crisis when a Richmond police officer made the split decision to escalate the situation instead of de-escalation in using his crisis intervention training. Instead of the officer positioning himself to be judge, jury, and executioner on the spot, the city of Richmond took great pride in trying to make the lowest moment of my brother's life wipe out all of his accomplishments and the amazing person that he truly was. I say to each and every one of you, my brother Marcus David Peters absolutely deserved help, not death. When a person's kidneys stop functioning properly, they receive dialysis if needed. When a person's heart stops functioning properly, they receive bypass surgery if needed. But the brain is the only major organ that when it stops functioning properly, we demonize, we incarcerate, and in the case of so many Black people, death is the final answer. As a longtime educator and school administrator, I think of the many times that I have de-escalated both situations of students and staff members who had mental health crises. I think about the many students that have autism and how they too could easily receive the same verdict as my brother Marcus David Peters. My family and I know that we can't bring Marcus back, but we can and we absolutely will continue to fight to hold every single elected official accountable for making the robust, courageous, progressive legislative changes such as passing the Marcus Alert Bill as a step towards putting community care and safety first and always. When you know better, you're expected to do better. I want to thank Delegate Jeff Bourne for being the most courageous legislator that I've had the opportunity to meet and work with, as he has clearly stayed far from taking the path of least resistance and is strongly advocating for bills that protect and serve our communities, as he is carrying the Marcus Alert Bill and the bill to end qualified immunity. I keep hearing concerns about funding, and I say to you, we make things happen that we want to make happen and that we make a priority. There's no dollar amount that can ever heal the voids that families are left with when their loved ones are taken away for having a mental health crisis. Please get rid of the excuses. Reallocate funds to ensure community care and safety is put first and always. I urge each and every one of you to put people over profit, to put people over politics, and to put people over police union donations.
My guys.
And vote unanimously in support of Delegate Jeff Bourne's life-saving Marcus Alert Bill. Thank you.
Thank you so much, Ms. Blanding. Thank you so much for your bravery and courage in being here. Dominique Martin, followed by Bruce Cruiser. Ms. Martin.
Good afternoon, Mr. Chair, and good afternoon to the members of the committee. My name is Dominique Martin, and I'm a policy research analyst at New Virginia Majority. I don't think I could really add too much more to what we just heard. We know that this is a bill that's sorely needed, especially in communities of color. And we know that getting the right type of resources allocated and sent to the right places, and especially in times of need, are especially important. And so we just urge you to support this bill and find a way to make it happen so that, you know, situations like the ones we just heard don't have to happen and continue to happen to members of our community. So thank you very much.
Thank you, Mr. Martin. Bruce Cruiser, followed by Anna Mendez. Mr. Cruiser.
Yes, thank you, Mr. Chairman, members of the committee. I'm the Executive Director of Mental Health America, Virginia, And I just want to commend the delegate and the family of Marcus David Peters for the hard work that they have done in putting into this to put this bill forward. We were not involved in that, but we fully support all the goals listed in the legislation. I think this is an incredible, significant step forward in really addressing the mental health needs of our community. The co-responder model of crisis response has worked in many other places in the country. And we certainly think that it ought to be coordinated with the Crisis Now approach in STEP Virginia, but with the Department of Behavioral Health, working with the Department of Criminal Justice Services on this implementation, I feel like that will provide the services that we need. So thank you.
Thank you, Mr. Cruiser. Anna Mendez, followed by Kofi Annan.
Thank you, Mr. Chairman. My name is Anna Mendez. I am the Executive Director of Partner for Mental Health in Charlottesville, Virginia. Thankfully, in Charlottesville, we have not experienced the police murder of a person with mental illness as happened in Richmond to Mr. Peters. But in Charlottesville, we do know that we arrest people with serious mental illness at disproportionate rates. There is no shortage of incredibly talented researchers in our city, and we have established two things. One is that we arrest and treat more harshly Black and Brown members of our community, and that we arrest and treat more harshly members of our community living with serious mental illness. The Marcus Alert System would give these people the opportunity to receive treatment and assistance rather than incarceration and a criminal record. Hopefully there are not many more deaths that need to be prevented. However, the continued criminalization of mental illness, specifically that of our Black and Brown members of our Commonwealth, is something that needs to be addressed, and we feel that this bill would be a good step in that right direction. I also have heard lots of concerns about funding, and all I can say to that is that as a community, we find a way to fund the things that we prioritize. Thank you.
Thank you, Ms. Mendez. Kofi Annan, followed by Michael Jones. All right, Kofi's not in the room. Michael Jones? Oh, Teresa Cueto Dickerson.
Hello. Thank you, Mr. Chair. My name is Teresa Keto Dickerson, and I'm from House District 87 and State District 33. I am a steering committee member of the VA Coalition for Transforming Policing. We wanted you to vote in support of the mental health crisis team submitting reports to the public safety committees of the Senate and the House, and not only the Joint Healthcare Commission. And we wanted to stress that we need transformation in Virginia, and that is all.
Thank you very much. Is Michael Jones in the queue?
Yes,
Or Tara Hassan Taylor.
Hi, good afternoon. My name is Tara Hassan Taylor, and I am a member of Moms Demand Action for Gun Sense in America, and also a member of Virginia Coalition for Transforming Police. But most importantly, I'm a mother of 4 children, 10 and under. My 7-year-old son has autism, and when the environment or school becomes too much for him, we are constantly threatened with police being called. We feel fear when we should feel comfort, and we feel ashamed when we should feel cared for. People in mental health crises or differently abled children and adults do not need to feel that way when they're in crisis. We need trauma-informed professionals that are trained to handle these situations. They do not need to be detained by law enforcement, and they certainly do not need to be shot and killed by police.
Thank you very much. We are now at 10 minutes, but I do have Valerie Slater as our last speaker. Ms. Slater?
My name is Valerie Slater, and I am a member of the Transforming Policing in Virginia Coalition and Rise for Youth. And I just wanted to share that underserved populations must be the first to receive the crisis response teams, because as Delegate Bourne shared, divested communities of color, they are the most policed and over-policed communities in Virginia. And so the need to develop a system that stops the criminalizations of Virginians with mental health crises and to stop the killing of those individuals in mental health crises, we must move this piece of legislation forward. We cannot falter at the idea that there is not enough funding. We find the funding for the things that we support. And so we must demonstrate that we care about every Virginian. Virginians that are of color and Virginians with mental health crises, we must prioritize the least of these. And so therefore, we are in support of this bill. Thank you.
Thank you, Ms. Slater. All right, we're moving over to the opposition side. I have Jennifer Faison. Ms. Faison?
Yes, Mr. Chairman, can you just give me a thumbs up if you can hear me?
I can hear you perfectly.
Okay, great. And I appreciate the opportunity to provide comments this afternoon. And to be clear, when you select how you would like to contextualize your comments, you're only allowed a choice of support or oppose. And I don't think that the VACSB opposes anything.
Category.
What's that?
But you think we should have a neutral category?
Well, actually, there may be a neutral category as well, but I don't think that anyway.
Okay. All right.
I would like to be clear that the Virginia Association of Community Services Boards absolutely supports the shared goals as outlined in this bill. And I don't want to talk about the money. I agree and would associate myself with the remarks of the individuals who spoke in support of this bill, in unconditional support of this bill. It is a reality, but I do think that there are ways we can come together on this particular issue and move forward. The concerns that the Virginia Association of Community Services Boards have really relate to kind of pinning ourselves into a particular model. And Mr. Chairman, I would suggest to you that while STEP Virginia does include a mobile crisis piece, that mobile crisis model seeks to avoid law enforcement involvement in cases where that's appropriate, to avoid law enforcement involvement at all. So it's a little bit more of an upstream solution and does not actually speak to law enforcement involvement as is envisioned in Delegate Bourne's bill. So I guess, just wanted to point out that as one of the members of your committee spoke to earlier, there are communities that are putting models in place. And the concern is that if there is a mandate for a particular model from the General Assembly, that they would either have to pause what they're doing, wait for this to occur, or dismantle what they've already done and put something different in place, depending on how this conversation shakes itself out in the entirety of the 4 bills that are before both the House and the Senate. And so, again, I think it is very important to keep our eye on the shared goals that are outlined in that bill, but to be very inclusive of community input and allow communities to meet those goals in a way that's most appropriate based on the resources that they have, the community needs that they have, et cetera. And I'll just give one more example of a different way that you could reach those shared goals. And that is to have, a behavioral health professional embedded in a 911 call center. And again, once you have appropriate training of dispatch, this is a model that's in place in other states as well. You have the opportunity to triage calls so that a lower number of those calls would involve law enforcement at all. So again, supportive of the shared goals as outlined in Delegate Bourne's bill and appreciative of getting those all on paper for us and putting them in one spot, but would seek flexibility for communities to develop programs that meet those goals in a way that's most appropriate to their resources. Thank you.
Thank you, Ms. Faison. Delegate Ferris, are you with us? Delegate Ferris?
Yes, sir. Yes, sir, Mr. Chairman.
You recognize.
Mr. Chairman, I'd like to say that I think as a community, it's very easy to treat mental health, just like some of the other speakers have talked about today. It's nothing different than someone that has diabetes or needs dialysis. And we've treated some of these people in a way that they're scared to ask for help. And so I understand this. I think really and truly, the sad part about this is the police are still going to be the first ones that respond. And I really would like for us to think about what we could do to spend this money within our police departments to have somebody there with them that has the ability to be plain clothed and to do this versus trying to organize different people from different parts. I hadn't heard anyone from the mental health profession speak today, and I was hoping to hear what they had to say about it if it was feasible.
Well, Delegate Ferris, we did have a number of people from the mental health community that spoke earlier on this. Let me go ahead and turn to Delegate Rasool. You recognize.
Thank you, Mr. Chair. Speaking to the bill.
You recognize.
Thank you, Mr. Chair. I think this is part of the frustration. You just heard the CSBs talking about having certain trained professionals, even in the 911 center, to be able to potentially dispatch someone other than law enforcement. This is the real misconception around many folks who are in the defund movement, who are wanting to reappropriate funds because right now, I've sat down with law enforcement myself in recent weeks, and you have a number of patrols who are in a certain quadrant, and if one of them gets tied to an ECO, that takes up most of their shift. We have made that conscious decision to place some of our resources, I think, in a way that doesn't necessarily serve society best. And so I hope that as this bill advances and moves along to appropriations, that we can think bigger than just the silos of what do we put in 599 funding, what do we allot to mental health. There is a lot that we put on local law enforcement that we could be making investments in a more responsible way elsewhere. Thank you, Mr. Chairman.
Thank you, Delegate Rasool. Delegate Price.
Yes, Mr. Chairman. Speaking to the bill.
You recognize.
Thank you, Mr. Chairman. I would like to thank the patron for his hard work on this. I think this is one of the pieces of the Virginia Legislative Black Caucus agenda that I've heard from the most by email and all of the ways that people can contact me. Also having served as the chair of the Behavioral Health Subcommittee and newly added to the Deeds Commission, hearing a lot of concerns from the ARC and organizations that are doing advocacy on their own behalf and also in conjunction with those that have mental health concerns and behavioral and intellectual disabilities. So I appreciate the move of the code section from criminalizing people for who they are to moving it to the section where we deal with how to engage and interact with systems. And so I just wanted to say that appreciation for that move. The other part is that I just want to make the statement that I would hope as the department is considering the professionals that will be a part of this, for them to think about those that are non-licensed within the field, but are on the front lines. And so oftentimes we give a lot of credit to the folks with licenses, and I have nothing against them, but there are some folks within the mental health and behavioral health community that are working on the front lines, that know the community, they know their stuff, but they just may not have the same certification as others. I think that will also help add some diversity to these teams around the Commonwealth. But in addition to that, Mr. Chair, I do have a suggestion as it goes along with what Delegate Corey was suggesting for the language accessibility. And so I do have, I was speaking with the attorney in agreement with what he may have come up with as we're multitasking, and wanted to offer that line amendment at the appropriate time.
You're recognized, Delegate Price.
Okay, and Council, the last one we discussed for the consideration, if you could report that one.
Sure, Mr. Chairman, some of the language we've worked on, this would go in the protocol section, and it would essentially say consideration shall be given to the particular needs of non-English speaking persons when developing such protocol and establishing community care teams. So it's a little less prescriptive, but directs the DBHDS, Department of Behavioral Health Services, to come up with essentially a protocol for addressing the needs of non-English speaking persons when coming up with how these community teams should be established, community care teams should be established.
Delegate Price, are you moving that amendment?
I am, and just to be very clear, carrying the same concern and respecting the same concern that Delegate Corey has so aptly raised, but also recognizing the limitations of our communication with the several advocates that may want to weigh in on this, should we take a more prescriptive way. I do move that line amendment.
Without objection, that line amendment is adopted. We've spent about a half hour on this bill already, and at this rate, we will be here at sundown. I'm going to recognize Delegate Wright for the final question, and then I'd like to entertain a motion on the direction to move this bill. Delegate Wright.
Thank you, Mr. Chairman. I didn't have a question. I just want to make a comment. The area that I serve needs more money for police, not less. I heard some discussion about the possibility of when this goes to appropriations to maybe find funding in the law enforcement area to go to mental health to help pay for this. Law and order is very important to our area, as it is to the whole state, but it's not just the money. I'm constantly hearing comments from the school systems and other divisions here in this area about constantly sending mandates back to our area and the whole state without the funding to go with it. And we just can't keep doing that. Also, the infrastructure is not in place. By that I mean it's hard enough to find deputies and police officers and mental health officials as it is, or mental health workers. And some of our mental health facilities in our area have actually stopped taking new patients. So that shows you the position we're in. And I would just ask that this be considered carefully, the effect that it'll have, and what happens on areas that just can't do it. In other words, when you can't get a mental health person to go and so forth. And it's going to cause a lot of confusion as far as when the call comes to 911, that sounds like that's when the critical decision has to be made. Is it really something, a mental health issue? Is it maybe somebody has gotten drunk or something else has happened that makes them appear to have that? And I know that mental health is a very serious issue, but I think that there's a better way to address it than having it involved with the police at this time. Thank you very much.
Thank you, Delegate Wright. So we've adopted a substitute, and we've amended the substitute. If the committee wants to act favorably on this bill, the motion would be to report the substitute as amended and refer to appropriations. Who would wish to make
So move, Mr. Chairman.
Second.
Second.
Second. Please vote on your electronic voting device. Delegate Ferris. Delegate. All right, clerk will close the roll. Bill reports and refers 13-9. Thank you, Delegate Bourne. I'm going to move around a little bit on the agenda and just in recognition of those that are on the phone that aren't on the committee. And the first on my agenda is Delegate Simon, House Bill 5051. Delegate
Thank you,
Simon.
Delegate, Mr. Chairman. Mr. Chairman, members of the committee, I have House Bill 5051. This is the police decertification bill, the House version of this. I want to just start off, I guess, with a little. Let me. Do you want me to start with some line amendments, or talk about the bill generally first, and then get into the line amendments?
Why don't you do the line amendments? We'll get it before us in proper posture.
Got it. So, dealing with some of the stakeholders, in particular, the state police had some concerns on line 35 and 36 of the bill, starting on line 34, where we require notification if someone's terminated, particularly small v, is terminated or resigns while such officer is the subject of a pending internal investigation. I think we wanted to add language that says for an offense which could result in termination. I think, Mr. Cogliato, is that what I gave you earlier?
Yes, Mr. Chairman. It was for conduct that could result in termination from the agency, and that these amendments should be online shortly, and that is the first amendment. And I believe you have a second amendment too.
Right, and then the second amendment is on line 54. So we have a new lettered paragraph H that says that any conviction of a misdemeanor that's been appealed is not considered a conviction yet. And I borrowed some language from the Senate version of this bill that says after the word entered, we have a new sentence. Any finding of misconduct listed in subsection B will not be considered final until all grievances or appeals have been exhausted or waived and the finding of misconduct is made final. So essentially for the non-criminal offenses, we give that sort of same due process that we give for criminal convictions. If it's not final, then it's not ripe for decertification yet. And so that was something that I know we talked about making a similar amendment. So those would be the two line amendments that I'd have and ask the committee to adopt to get this in the right posture.
Can I get a motion to move the committee amendments?
So moved.
Motion, all in
Second.
favor? Second. Any objection? All right, without objection, the amendments are before us. The bill's before us. Delegate Simon, you're recognized.
So, Mr. Chairman, members of the committee, this is again the decertification bill, and this is the bad apple bill, if you will, right? I think we heard during our combined hearings earlier this month from a number of folks, regardless of how they sort of felt about these issues. Generally, one of the areas of consensus, I think both the police chiefs and the police departments and advocates for both sides thought that we needed to make it less difficult to get rid of officers who didn't belong in the policing profession and to keep them from bouncing around. It turns out that Virginia's decertified just 33 officers last year, as opposed to a nationwide average of about 681. So about 5% of what you would see in the average state. So this is not, this is something where it is difficult. I think even the law enforcement professionals concede that you have folks to take advantage of a loophole. If they're about to be convicted or about to be found terminated for cause, they resign first to avoid that finding so that they can go find a job somewhere else. So I think we're trying to just close the revolving door or put a stop in the revolving door of these bad police officers going from department to department. I'll point out a couple of things. Again, by adding, I think, for an offense that's fireable, we beefed it up a little bit. I know that there was some concern when I talked to the state police that somebody could be being investigated for something as minor as being frequently late to work and failure. We used to call in the Army failure to report type violations that were more workplace that didn't necessarily go to their fitness to be an officer. So I think by adding this language that says for something that's basically a fireable offense, we tighten that up a little bit. And I know that again, the Senate has a slightly different approach as far as that piece. For what it's worth, about the only difference is the Senate required a violation that's serious misconduct is defined in a statewide professional standards of conduct that they have the DCJS adopting. We don't have similar language in our bill that requires that. That said, I think if you've been corrected, even if it's a relatively minor thing, if you've been corrected on it so often that they're ready to fire you for it, you have a problem with authority and listening and following directions. That probably makes, if you're unfit to be a police officer in Fairfax, for whatever reason, I don't think you should turn around and be a police officer in Loudoun or Richmond City or Norfolk or Hampton. So that is the bill, and I await the pleasure of the committee, and I'm happy to answer any questions.
Thank you, Delegate Simon. I see a bunch of hands up, but I don't know if those were hands up from the last bill or this bill, or you're just really talkative. Delegate Corey, you wish to be recognized? Delegate Corey?
No, sorry, it's from last time.
Delegate Robinson? Delegate Robinson, do you wish to be recognized?
No, sir. Sorry about that.
Delegate Wright? Delegate Wright, do you wish to be recognized?
Sorry, no, that was last time.
Delegate Batten, do you wish to be, am I just going to go down the list here? Delegate Batten?
Actually, I do have a question
Hey,
for
okay,
the patron.
Delegate Batten.
I'm just wondering if it's possible to get a copy of those amendments. I know that the comment was made that it's more similar now to the version that passed the Senate, and I was just kind of trying to get a side-by-side there. So it didn't seem like they were huge amendments, so I was hoping we could get a copy of those.
Mr. Chair, the amendment should be available on LIS. So if you look up for the bill number, it should pop up under a link that says amendments offered, and the amendment should be there.
Very good. Thank you.
Great, thank you.
I don't see any other questions, so I'm going to turn to the witnesses that we have in the queue. First up is Eric Smith, followed by Dominique Martin. Mr. Smith?
Thank you, Mr. Chair. My name is Eric Smith. I am the Acting Director for the Law Enforcement Division at DCJS. Right now, I think we're in the posture that the administration supports expanding decertifications in general. However, we would note that this bill may have a fiscal impact in that it would increase the number of decertifications. Thank you.
Thank you. Dominique Martin, followed by Kofi Annan. Mr. Martin?
Thank you again, Mr. Chair. Again, Dominique Martin, Policy Analyst, New Virginia Majority. We're supportive of bills that increase the transparency and accountability with law enforcement officers. And so we believe this bill accomplishes that. And so for that and the reason presented by the patron, we support the bill.
Thank you. Kofi Annan, followed by Kelly Harris Braxton. Mr. Annan, he wasn't in before.
Yes, good afternoon.
Oh, good.
Yes, thank you. Sorry about the technical issues last time. I was here, but I'm not sure what happened. Nevertheless, again, my name is Kofi Annan. I'm the resident of Fairfax County and president of the Activated People, and is also a steering committee member of the Virginia Coalition for Transforming Policing. I'm here to testify in support of the bill. I do believe that officers need to be decertified once they are found to have committed egregious acts that violate citizens' rights. After the coalition, after George Floyd's murder, the coalition convened a series of meetings all across the state, which we gathered the opinions of hundreds of Virginia residents. And one of the most common themes coming out of those meetings were that people wanted the police to be held accountable for their actions. And part of that accountability measure was to make sure that they don't just, once an officer is held accountable or fired from one jurisdiction, they aren't allowed to just simply bounce to another jurisdiction to continue doing their bad behavior. This is also a very commonly held value among officers themselves who do value their profession and want to maintain the respect of the department. So thank you again for your time, and I hope we do support this bill.
Thank you, Mr. Annan. Our next speaker is Kelly Harris Braxton, followed by Steve Patterson.
Good afternoon, Mr. Chairman, members of the House Judiciary Committee. My name is Kelly Harris Braxton. I'm Executive Director of Virginia First Cities Coalition, a coalition of 16 of Virginia's older core cities, and we are supportive of this bill, House Bill 5051. We have taken a deep dive into police reform initiatives ever since 2015, when the senseless use of force was used on Freddie Gray in Baltimore and Michael Brown in Ferguson, Missouri. In 2015, in response to the senseless use of force, we decided to take a deep dive into police reform initiatives. We convened a panel discussion comprised of our police chiefs, our city managers, and outside experts in the field of law enforcement, entitled Every City of Baltimore, Policing Today. The panel and subsequent policy dives resulted in recommendations for law enforcement reform. Criminal justice reform is a major current concern for our members, the cities. Council members and city managers for our cities who've seen a lot of action. And they have a number of policies that are being discussed during the special session that are priorities for First Cities. And so in addressing House Bill 5051, we certainly support this bill. It removes officers who need to be removed and improves the pool of officers in our communities. We want the best officers available, and it promotes transparency and accountability, which is very important to our members, our leaders in the community, and also our police leadership. And they're very supportive of this bill, the ones that I have had conversations with, and we support it strongly. Thank you.
Thank you, Ms. Harris-Braxton. Steve Patterson, followed by Alan Charles Chipman. Mr. Patterson. All right, Alan Charles Chipman.
All right, greetings everyone. I'm writing in support of this bill. Many know of the death of Mike Brown in Ferguson, Missouri, that launched the phrase Black Lives Matter. Many do not know that Officer Darren Wilson that killed Mike Brown came from a police department called St. Jennings Police Department that was closed for multiple civil rights violations. Instead of accountability, those offers simply were spread to different departments. In 2006, an officer in Buffalo Police Department reported an officer for using an illegal chokehold. No accountability was given for that police officer, and that same officer ended up slamming and abusing teenagers and berated them as, and I quote, savage dogs. Our police chief right in Richmond came from a department in Mecklenburg that Superior Court Judge Edie Williams had to offer a restraining order for abusing protesters, and it now has been revealed that he was involved in the case for bringing charges without probable cause. But instead of facing charges, they were allowed to simply move to a different department. The process of decertification is an important point of accountability. And if any department that lacks accountability is simply giving permission for bad behavior in the future, we support this bill and thank you for your time.
Thank you, Mr. Chipman. Thank you for your testimony. All right, I see no more hands. We did get a letter from the speaker that this needs to be referred to appropriations if we are to act favorably. Delegate Will, your hand's up just in time.
Thank you, Mr. Chairman. Question for the patron.
Delegate Will.
Thank you, Mr. Chairman. Yeah, my question is in the body of the bill, it talks about the receiving 3 complaints against the officer. What's the process in determining the legitimacy, the accuracy, the truth or not of those complaints and those charges that are brought up? Is that, yeah, that's my question.
So, Mr. Chairman, members of the committee, I think, and this is a section I didn't really speak too much when I was doing my initial presentation. It comes at the end of the bill. I didn't mean to give it short shrift, but it does say that, and this is new language that wasn't there before, that if a sheriff, police officer, or administrator will also notify the board and the civilian review panel, if there is a civilian review panel, if any certified law enforcement or jail officer has received 3 complaints of excessive use of force in the previous 5 years. And so there's no, Delegate Wilt's correct that there's no requirement that they be founded or that they be convictions or that they be, they not be contested. But I think that the idea is that 3 and 5 years, the frequency of the same kind of complaint against the same officer, that over such a short period of time tends to give credibility to it. And so all it is a referral, and that would give the board, if there is one, or this DCJS, if there's an opportunity to look further into the circumstances around those complaints of excessive force. And so it's designed to be an early warning indicator of somebody who's got a pattern or practice. And so if they find that all 3 of these just happen to be completely made up fictional events of the same officer, they wouldn't be required to act. But I think that the issue here is not to try to, there's a pattern that's emerged over time. that merits a further look by either DCJS or if that locality has one, a civilian review panel.
Bella Levine, you have the last question.
Actually, thank you, Mr. Chairman. I move to report the bill and refer it to appropriations.
As amended.
As amended.
Second. Properly second. Please vote on your electronic voting device. I will ask the clerk to call out the remaining or have not voted. All right, bill reports referred as with amended 16-6. Thank you, Delegate Simon. Next, non-member of the committee is Leader Herring. Madam Leader, are you there? House Bill 5055. All right, she's on her way. Delegate Herring. Leader Herring, you're recognized. House Bill 5055. And you're muted, I believe.
Please unmute your microphone.
Thank you, Mr. Chair, members of the committee. HB 5055 is the Civilian Review Board bill. Mr. Chairman, there is a substitute that Mr. Quagliato has.
Mr. Quagliato, do you want to report the substitute?
Mr. Chair, I am publishing the substitute online. It should be up shortly on LIS.
So, Mr. Chair, do you want me to go ahead or?
Yes, Leader Herring, can you explain it?
Oh, absolutely. HB 5055 does require that each county and independent city form a civilian review board according to their local processes no later than July 1st, 2021. It does require a minimum of 3 members, a member from a historically economically advantaged community as defined in section 56-56 of the code, that has long experience disparate policing. The second member would be of a racial justice or civil rights organization, and the third from a mental health practitioner or social worker. And that, again, that's the minimum requirements. The board would make recommendations for corrective action on gross misconduct, excessive use of force, or criminal offenses committed by law enforcement officers. Any local law, according to the bill, any local law enforcement agency that receives 3 complaints of excessive use of force within a 5-year period or bias profiling would be required to submit that basically a case file to a panel for review of the complaints and make recommendations, and the panel would make recommendations for corrective actions. The recommendations are, if the recommendation is not adopted by the panel, it should be responded to. And the bill does also provide a subpoena power. The Civilian Review Board may request records and information from the police department or the sheriff's department, and if it is not provided, the Civilian Review Board may petition for a subpoena. Mr. Chair and members of the committee, I realize that there is a lot of discussion going on about, whether this should be a mandate or not. And I submit to you that this is our opportunity to require this straight across the Commonwealth of Virginia. And I'll give you some reasons why it's important. We need to have consistency across the Commonwealth when it comes to civilian review boards. Systematic issues need systematic responses, but best practices of civilian oversight of police needs need to have community input. That's why the bill is designed as a floor and not a ceiling. This bill would not prevent localities who have already started their civilian review board process, and establishing them would not prevent them from doing what they are doing. Also, with respect to the mandate, this would also require that the locality provide notice and have an opportunity to hear from the public about the selection process of who will be on the civilian review board. It is important to note that civilian oversight can help build trust and provide law enforcement agencies with real feedback. I want also the committee to know that 60% of the civilian oversight boards that currently exist are based on the review model. And this is one of the primary reasons that the legislation starts with a review recommendation. But this does not, again, prevent localities from expanding it to a more comprehensive program. Also, I will note, I know that there is a lot of desire to have this bill be like the Senate bill, but the Senate bill leaves out sheriffs. And I will remind the committee that 65% of localities' law enforcement principally comes from sheriffs and their deputies. So basically, if we do not do this as a straight across for all law enforcement, we'll be leaving 65% of Virginians behind. So, Mr. Chair, essentially those are the principles of the bill, and I just wanted to let you know I do have representatives from the NAACP here to testify in support of the mandate, as well as a representative from the National Association of Civilian Oversight of Law Enforcement, as well as a representative from the City of Alexandria.
Thank you, Leader Herring. And how we're going to proceed for this bill is, before we adopt the amendments, let's go ahead and hear the testimony first. Then we'll have a discussion with the committee and the patron. Since there are a number of people that have signed up to speak for this bill, in opposition to this bill, I'm going to put another time limit on the for bill, 10 minutes total, and for the opposition, 10 minutes total. And so with that, why don't we go ahead and start on the first item, Jeffrey Fogel. Oh, not in the room. Okay, I'll move down to Dominic Martin. You're a regular today, Mr. Martin. Thank you for coming. He's left the room. Boy, he's had too much of us. Margot Frazier.
Good afternoon.
Hi, Ms. Frazier. Welcome.
My name is Margot Frazier. I'm the Vice President of the National Association of Civilian Oversight of Law Enforcement, commonly known as NACOL. I happen to be a retired Texas sheriff and also the retired police monitor for the city of Austin. NACOL is the leading organization that is furthering civilian oversight through both informational and educational efforts, as we feel that civilian oversight is a critical facet to promotion of effective policing and to accountability and transparency. I'm sorry?
Okay.
Please continue. Delegate Ferris, if you go on mute, I appreciate it very much. Please continue.
I want to congratulate Virginia for this very bold step in requiring at least a civilian review board across your great Commonwealth. And also the fact of not limiting the ability of the local communities who choose to expand the authority and the powers of their civilian oversight authority. House Bill 5055 checks a lot of the boxes of the 13 principles that are key to effective civilian oversight. And NACOL stands ready to work with you in any of your communities as you go about finalizing this bill and implementing it. Thank you, sir.
Thank you, Ms. Fraser. Next speaker is Gayleen Kenoyton.
Good afternoon, Mr. Chairman and members of the committee. My name is Gayleen Kenoyton. I am the Virginia State Conference NAACP Political Action Chair, and I'm also Vice President of Region 1 for the Virginia State Conference NAACP bill. I am speaking in the spirit of HB 5055. The National NAACP has been advocating for civilian review boards for a very long time. As a matter of fact, today I just happened to pull up a bill that the former delegate Mary T. Christian had a bill in 1995 in support of this. So this has been going on for a long time. And I wanted to just read a couple of the stipulations that National has provided for us, guidelines for us to go by. and the establishment and the effective and independent civilian review boards to examine policy activity. We must restore and give power to local communities and agencies, which is meant to protect and serve. Therefore, the NAACP would like to see, accountability and review boards in every local, state, and federal law enforcement agency. What the exact composition of these boards should be determined by the needs and makeup of the community being served. In order to be effective, they must all have the following. The review boards must be independent in that will have the power to conduct hearings, subpoena witnesses, and report findings and recommendations in public, and it shall house from the police headquarters to maintain credibility. Number two, it needs to be relevant and have the power of independent investigate incidents, subpoena power, complaints. Finally, the effective citizen review board should be reflective of racial and ethnic makeup of the community in the board and staff and broadly representation of community it serves. The review board must be adequately funded, fulfill the obligation laid out above, and it should not be lower budget priority than police internal affairs. And with that being said, I've gotten a lot of phone calls, and I just want to say this. We don't support the DCJC to be funded. DCJS to be funded at all on behalf of organizing CRBs. We think that law enforcement and local elected officials should be independent in developing or choosing who will sit on the CRBs as well. We also think that 3 incidents in 5 years is too long to be reported and investigated. We think it should be 3 years on racial bias incidents should be done within 3 years, 3 incidents within 3 years. Finally, I just want to say that I want to thank everyone that has called and reached out to us in support and talked about their concerns. This will never be a one size fit all, but I will say this, option and if has always been a barrier for a real CRB. And I want to also say that, Injustice has been funded for 401 years and injustice bills have been passed. It's time to pass and to fund justice. Perhaps if we had a CRB in Richmond, Marcus Davis Peters would still be here. Thank you.
Thank you very much, Ms. Knoyton. Next speaker is J.D. Spain, Julius Spain. Mr. Spain.
Well, Mr. Chair and distinguished leaders, my distinguished colleague Galen Connaughton took a lot of words right out of my mouth, so I won't be long, but I do have some remarks. I come to you as president of Arlington Branch NAACP and as regional vice president, Region 3 North NAACP, the Virginia State Conference, where I oversee about 13 branches in Northern Virginia. And I just want to take a moment to remind you, as we come up on the 57th anniversary of a historic march on Washington, where the Reverend Dr. Martin Luther King delivered I Have a Dream speech, we have to ask ourselves, has the calls for equity and freedom fallen on deaf ears? So for each of you at this special session, this is clearly a moment of reckoning. Shortly after the tragic events of our brother George Floyd, the National NAACP, as my friend Galen Connaughton stated, gave us a mandate to go out and petition our locales, our states on civilian review boards. House Bill 5055, though it is not perfect, it's a start. So I'm here today on behalf of NAACP branches in Northern Virginia and the Virginia State Conference to ask for your support. This is a mandate. We have thousands of citizens who are asking for this, and you should deliver. Anything less of this mandate, in my opinion, is a failure. So we've heard from Nicole, and I just want to mention something that Nicole puts out, the National Association for Civilian Oversight. The ultimate goal is to increase confidence in police. We know this. Civilian oversight works to increase public trust and confidence in the police. The only way we can honestly do this is having independent reviews. and audits of police policies and practices, and by ensuring that these processes are handled fairly and objectively. Fairly and objectively. Thank you for your time and attention.
Thank you, Mr. Spain. Let's go ahead and move over to the opposition side. Kim Rolla, followed by Sarah Burke. Kim?
Good afternoon, Chairman Hope, committee members. I had the pleasure of speaking with you all last month. And once again, my name is Kim Rolla. I'm the interim legal director of Legal Aid Justice Center's Civil Rights and Racial Justice Program. I want to note the complexity of the word oppose because I'm here to urge you to amend HB 5055 to reflect community demands and nationally recognized best practices. I haven't had time to do a deep dive into this substitute that was just introduced, but looking at it, we still have some serious concerns with the legislation. One of them is that civilian oversight is about community power. Meaningful and effective civilian oversight, it has to be community driven, it has to be responsive to local needs. And this substitute still gives, as the woman from the NAACP state branch mentioned, immense power to the Department of Criminal Justice Services, a state level agency, to dictate from the state down minimum standards, guidelines, and best practices that must be complied with. And the way I read this legislation, that's not a floor. That is really that could structure civilian oversight in Virginia. And again, I think we need to be looking to build community power and not giving institutional actors the ability to define our civilian oversight mechanisms. Second, civilian oversight is very narrowly defined in this. I think as Leader Herring mentioned, starting with kind of a review model approach, it's individual complaint review and only the most egregious individual complaints. And we really want localities to be encouraged to address many forms of oversight, whether it's auditing, policy recommendations. It's a Swiss Army knife. It's not one tool that is just ratcheted up or down. And the subpoena power in this legislation is only within the scope of the quote hearings, and only if localities allow hearings to be held and choose to allow subpoena power. Finally, no civilian oversight body under this legislation can make final disciplinary decisions. And we know that's a serious barrier, especially when trust has been breached in communities, because we know that police chiefs are free to ignore the recommendations of the civilian oversight body. I certainly want accountability mechanisms that are meaningful in every part of this state, but I want to make sure what we build is meaningful. So from our community partners, we've heard that means empowering broad array of potential oversight functions, enabling subpoena power that covers the whole breadth of those functions, and then allowing those oversight bodies where appropriate to have final disciplinary authority. So I encourage you to consider amending HB 5055 and empowering real, meaningful civilian oversight in Virginia. Thank you, Mr. Chairman.
Kim, before you leave, Delegate Bourne had a question for you.
Thank you, Mr. Chairman. A couple questions. One, I guess could you talk briefly about the thought, if you were involved or if you know, behind leaving the sheriffs out, one, and then two, I share your appreciation and your support of the subpoena power, the other things substantively that make this bill a little different. But I wonder whether or not a mandated quote unquote Senate version that also includes sheriffs is a much better bill that better addresses the issues that we're trying to get at as either compared to either of those bills that that are being considered now.
Delegate Bourne, I can take those in order or try to and be brief to, I know lots of people would like to speak, but my understanding is that there's some legal complexity when you consider final disciplinary authority enabling legislation, which the Senate's was, a final disciplinary authority over a constitutional officer. But I will say this, I think the office of the sheriff is created by the Virginia's Constitution and it's elected by counties and cities, but the sheriffs and their deputies are subject to regulation by the state. And that includes under current statute, when conditions they and their deputies can be removed from office. So again, in acknowledging that complexity, I think that's a piece of it. I certainly would invite members to look at that and consider whether sheriffs could be brought under final disciplinary authority. I also think that, is obviously a question the Sheriff's Association had raised of, it's a political question as well that I think the members would need to grapple with. But our position is certainly that sheriffs are subject to regulation by the state, and that currently includes what conditions they can be removed from office. And again, we believe final disciplinary authority is an important component of this legislation. And then to your point about the enabling versus mandate, I would just echo again that we really, from our work at the local level in Charlottesville and Richmond, have seen what a fight it is to make these bodies meaningful. Meaningful and effective civilian oversight has to have a base of community power. And I just want to say that I really, with humility, have heard the disagreement about this among advocates and community members. And I can only speak from my experience that I don't think we want veneers of accountability to be set up. I think that could be detrimental to efforts to meaningfully transform policing. We want to make sure, our goal is really to make sure that when these bodies are set up, they are reflective of and representative of community power.
Delegate Price, did you have a question?
Yes, thank you, Mr. Chairman. I was going to ask, I heard your comments about DCJS being over it, and I just wanted to know, trying not to get off of this screen so I couldn't look into it, what were the oversight bodies for some of the other models in hearing community power, but what is another model if it's not DCJS being over, the process?
And I would defer to Leader Herring to describe kind of her intended role for DCJS, but in my understanding is still under the substitute that DCJS would be promulgating, it seems like, regulations, and those would include minimum standards as well as guidelines and best practices that would be mandated to be, every civilian review board would have to comply with those. And I think the alternative approach in the language that the Senate is working with is that it would be enabling legislation, and it would be completely the community's discretion what the civilian oversight body would look like. It enumerates, including but not limited to, but it's not prescriptive. It really allows the community to define what civilian oversight is necessary for that specific community, rather than DCJS kind of creating a structure and saying that must be applied uniformly around the state. And I understand the substitute now changes to the wording of minimum standards, but I believe when we have DCJS promulgating regulations that must be complied with, that will still cabin the possibilities for communities.
Thank you, Kim. Next speaker is Sarah Burke, followed by John Jones.
Good afternoon, Mr. Chair and committee members. My name is Sarah Burke. I am one of the initial Civilian Review Board members in the city of Charlottesville and also a member of the People's Coalition. I've received 8 hours of training from the National Association of Civilian Oversight of Law Enforcement. I want to thank Delegate Herring for proposing oversight legislation. Unfortunately, I haven't been able to read the substitute bill, so I'll just speak in some broad strokes. Overall, I agree with Kim Rolo's concerns that they just mentioned about the limited scope of authority, the limited subpoena power only being at a hearing level, the lack of disciplinary authority and only the ability to make recommendations for corrective actions, and as well as, I think most importantly, sort of who gets to make the determination about what oversight means for a community. In most states around this country, all other ones, localities determine oversight by building community power and determining exactly what's necessary in the community, and then choosing an oversight model that meets those very particularized demands. So for example, in Charlottesville, we heard significant concern of a long history of racial profiling with stops, as well as complaints within internal affairs never being heard at all, never being investigated or addressed, and complainants never hearing back. So a review style model, or at least starting there, wouldn't actually meet the specific community demand here, because it's still highly reliant on the internal affairs investigative process, and it doesn't actually meet some of those more proactive elements that that civilian oversight can have, where you can look at policies and practices, you can look at data, you can examine, you can have an auditor, a professional independent auditor to audit police activities. And my understanding is that the intention of this bill is not necessarily to limit that community imagination, but the way that I at least read the initial bill sort of does set a ceiling for civilian oversight that is fairly limited in scope, possibly just as a starting point, but at least in a place like Charlottesville and also in Fairfax, where the community needs have been clearly identified, I worry that this actually might limit the ability for meaningful civilian oversight. So I want to thank you all for your time.
Thank you, Ms. Burke. John Jones, followed by Chelsea Wise. Mr. Jones, would you please unmute?
Okay, how's that?
Yes, sir. We got you.
All right, thank you, Mr. Chairman and members of the Public Safety Committee for taking my testimony. I'm representing the Virginia Sheriff's Association and some 8,400 deputy sheriffs across the state. You know, we had oversight civilian review for the last several hundred years because sheriffs have the ultimate civilian review. They are elected at the ballot box. And as many of you know, when there's an election for the local sheriff, it's usually the hottest election on the ballot, especially out in the rural areas where sheriffs are the primary law enforcement agency. There are 86 of those sheriffs. And, you know, when the candidates are running, it's a free-for-all, and the public can't be involved any more than what they are now. So when the sheriffs are elected across the state, they feel like they have the confidence of the public. Now, sheriffs are reviewed by a lot more than the public, and it's not like we go into office and we stay there 4 years and lay back and you know, do whatever we want to do. Sheriffs are investigated by grand juries, and they are investigated on civil rights complaints by the U.S. Department of Justice. If there's a criminal situation, they're investigated if it's approved by the Attorney General and the governor, or a grand jury by the Virginia State Police. And that's criminal and that's civil violations, and they're also sued regularly. We spent last year some $783,000 in legal fees defending suits, many of which we won. If we are wrong, you know, that comes out too. So, you know, if you have a citizen review board, and I know it sounds great that you're going to have citizens reviewing it, but I don't think this bill will give the proponents what they think they're going to get. And what I mean by that is, if you have a citizen review board for a sheriff, what you're going to get are those clamoring to be sheriff on the citizen review board. You will not get a pure product. You'll get people that have just been defeated running for sheriff, or their friends, or the next candidate that wants to be sheriff, and it'll be a constant turmoil for the sheriff for the wrong reason. It won't necessarily be for a civil violation or excessive use of force. It will be because someone wants to be the sheriff. And that's their only reason for opposing this bill. You know, I've worked with the Senate, and what we want to do and what we will do, and we've promised the Senate we do this, is to come up with a review by individuals, and we'll put a bill in as soon as we can, this short session, to a review by someone that's, you know, objective and professional and not related to any political agenda. And we'll come back with that and have some kind of a review for sheriffs. But to have a review for a constitutional officer that's elected by the people, by a committee, it's going to be a conflict for the sheriff. And
you wrap up, John. You wrap up. But Delegate Bourne had a question for you, Mr.
Yes,
Jones.
Thank you, Mr. Chairman. Before I get into my questions, I do want to say that I guess I don't immediately assume ill intentions when considering whether or not to support a bill, and I certainly wouldn't. I would hope that Mr. Jones is not suggesting that the members of the body who have developed these pieces of legislation or supporting them are doing so purely out of a political agenda or beholden to some other ideal other than this issue has been going on since the representative and the NAACP said, since at least 1995, with one of, if not the most courageous and classy delegates that's ever served, Mary Christian. but I'll reserve comment for that. And I appreciate his promises to the Senate, but we know where the road to good intentions lead. Mr. Jones, would you? I intellectually at least appreciate, and from a legal perspective, the idea that sheriffs do have a quote unquote, as you've described it, civilian review board every 4 years with their elections. Couple questions. Their deputies are not elected, are they?
Mr. Chairman and Delegate Bourne, no, the deputies are not directly elected. First of all, let me address my intent and my comments. The key word is unintended consequences. My comments by no means suggest any will intent on a political agenda or anything else, because it can happen on both sides. And I think purely, I've never heard any of the proponents talk about this, and I really believe this would be an unintended consequence, certainly not intended. So let's clear that up right now. Now, Delegate Bourne, on the issue of deputies, there's a difference between a deputy and a police officer. They are not elected, but they are appointed by the sheriff, and they serve at will. And the term of the deputy is consistent with the term of the sheriff. So when you have a sheriff and his term expires, all of the terms of the deputies expire with that sheriff. And many sheriffs around the state at the end of the election, they use that as an opportunity to clean up everything. If there have been complaints, if there have been issues that have come up, it's a good time to not reappoint all of the deputies. You know, we have a new sheriff school every time there's an election. And what we tell them is you've got to appoint all of your deputies, even if you are reelected and you've got 500 deputies, they still need to be reappointed. So while they're not elected, they serve at will, and they are an extension of the sheriff.
You have another question? We do need to run.
No, I'll practice some restraint here, Mr. Chairman.
All right.
Thank you.
Thank you, Delegate Bourne. Our final witness for the no category is Chelsea Wise. Ms. Wise, are you here?
Yes.
Ms. Wise?
Hello?
Be reappointed. So while they're not elected, they serve at.
Go ahead, Ms. Wise. I don't know what that was. Please. Are you on mute?
Hi. Sorry about that, having a little bit of technical difficulties. But my name is Chelsea Higgs Wise, Executive Director of Marijuana Justice and Steering Committee member of Virginia Coalition of Transforming Policing here. I'm here to support a broader scope of oversight, which is the language advocacy community groups have vetted and been working on. As we look to mandate in the future, we must better understand the models that best fit the unique areas across the Commonwealth. We must have buy-in from each area, specifically where Black and Brown people make up smaller portions of the population, before we mandate a system that they are unaware of is even happening, much less their options for their best district being unheard. As a local government advocate, I know how hard it is to dismantle a program put together by public officials who were not able to be informed by their constituents, while also being charged to build an oversight body that best fits for my place, space, and time, which is so important right now, this very unique time. So I am thanking the committee for voting to pass for bill language that really enables civilian oversight for now, and engage to make sure that we don't leave any locality behind from hearing for them on what's their best fit for community oversight. Thank you.
Thank you, Ms. Wise. On the pro category, this will be our final speaker. I goofed and I didn't recognize Sarah Taylor. She is speaking in support of the bill. Ms. Taylor, are you here?
I am. Good afternoon, Mr. Chairman, Leader Herring, members of the committee. My name is Sarah Taylor. I'm the legislative director for the city of Alexandria, and I'm here today to speak in support of Delegate Herring's bill. I feel like a lot of us are really coming at this from the same place, where we want localities to have the authority that they need to set up civilian review boards panels that are appropriate for their communities and that are responsive to the concerns and the perceptions, the needs, the problems in their own communities. And reading Delegate Herring's bill, we believe that her language actually provides us with the most flexible authority for us to be able to set up a board that is correct, that is right for us. In addition to my glamorous position as the city's lobbyist, I've spent the interim working on the city's plan and proposed ordinance to establish a community policing review board here in Alexandria. In May, our city council tasked us with coming up with such a proposal, and we are working towards presenting one to council on the 8th of September. And in doing my research and speaking with the subject matter experts, I came away with two major points. The first is that if you've seen one community police review board, you've seen one community police review board. And while there are best practices and principles and standards and guidelines that can be reviewed and that you can base your community police review board on, there's no one single model and no one set of duties or authority that will fit the needs of every community. And in addition, in order to be successful, a community police review board needs to be unique to the community it intends to serve and must have the scope and authority necessary to be responsive to that community's needs. It must be built on the engagement of local stakeholders and robust community input, not prescriptive statewide mandates. And we believe that Delegate Herring's bill affords us the flexibility that we need to establish the community policing review board that's right for our community. We believe that the minimal requirements in the bill serve as a floor rather than a ceiling. We believe that it will allow us to establish the community policing review board that's right for our community. And in addition, we believe that the legislation will give us the flexibility to allow our board to grow and evolve as we learn more about policing in our community as the board does its work, without us having to come back to the General Assembly to ask for additional authority. I mean, we know how much you all love when we come back asking for additional authority or another ornament to hang on the Christmas tree. And we really believe that the very broad non-prescriptive authority that's granted to us in Delegate Herring's bill is appropriate and will provide us the flexibility to establish and nurture and evolve the appropriate policing review board for our community. We're grateful to y'all for hearing from all of us. We're grateful to Delegate Herring for carrying this legislation, and we look forward to working on this as we move forward through special session with y'all. Thank you.
Thank you very much, Ms. Taylor, and I apologize for missing you earlier. All right, so let me turn it to the committee now. Delegate Bourne.
Thank you, Mr. Chairman. And maybe you ought to come back to me because I may have a motion for a substitute, but I did just want to kind of get the patron's sort of response to her reception of a substitute that would conform hers to the Senate version, because in my estimation, the subpoena powers that are in the Senate version, the DCJS level of involvement pose some real concerns for me. And I obviously don't speak for anybody else in the committee, but I'd just like to hear sort of how she might react, because I'd never want to make Delegate Herring angry or upset with me.
No, thank you, Mr. Chair. If I may respond.
Leader Herring. Yeah, she's a real meanie. You got to be careful with her.
Thank you. And look, I'm all for more subpoena power. I would support that. I would just note for the DCJ aspect, I would just note that we're also, there's legislation to change the composition of DCJS so we have more voices from the community. So look, I mean, that would be the will of the committee, but what I am here today to fight hard for is that mandate, and this is why. And those of us who've been around the legislature knows typically what happens. We do not do this now. We will then leave for future legislators to decide. And I say that because it is going to be more difficult to make the requirement on the back end. We're going to have dragging feet. This is our first time speaking, and I would like for us to be bold and require it. To me, this is just as important as school boards in the locality. This is just as important as community services board. And then on the other thing, Mr. Chair, just one more thing, and something that I heard that was interesting is that the sheriffs are complex. This is not complex. Yes, sheriffs are constitutional officers. But if we buy the argument that was given to us, that means there could be excessive use of force by a deputy sheriff within the first year of the 8 years of the constitutional officer's service. And we have to wait 7 more years before a new sheriff is elected and house is cleaned. Think about that. That's why I think sheriffs need to be included. And those complexities and why I had the DCJS involved is to sort of work that out. And that's a place to work it out. But I think this is a time for us to be bold in the NAACP, and I appreciate their comments. This is not, let's do the piecemeal part. Let's be bold. Let's talk about law enforcement. And if if we exclude sheriffs, we are saying to 65% of Virginians, where that is their major law enforcement, that you don't get this. This is for only those cities and localities like Alexandria City that have a police department. So I am open to the subpoena, but I'm fighting hard today for the mandate and to include sheriffs.
Follow up, Mr. Chairman.
Delegate Bourne.
And I guess maybe this is more of a question for council. Is there a way to potentially because I agree with our majority leader in that if we can do it, we need to do it now. I do believe that we're leaving a big portion of law enforcement, which sheriffs are, on the table if we don't include them in this, and whether or not we can strengthen the subpoena power to sort of mirror the Senate. And then one of the other issues that I failed to mention was sort of broadening the scope of the reviews that these CRBs can do, and whether or not we can come up with a product that really is reflective of the priority that we put on this being a mandate, 2, that we mean business when it's subpoena power, and 2, that they're going to have a broad enough scope that they can get at the root of what I think a lot of people in the communities really want, which is more oversight from the community's perspective, but also give the localities flexibility to set them up in the way that fits their community, so that they're not just sort of I think it was called a veneer board. So I guess that was a long-winded question for council.
So, Mr. Chair, I'll try and unpack that question. I think the first answer, dealing with the subpoena power, I am not certain there's that much of a difference between the current substitute before you and the Senate's bill in terms of subpoena power. I think they both closely track each other. I think the witnesses were mainly concerned about that the subpoena power is tied to the civilian review panel holding hearings. And I think the envisionment of this was that because the substitute requires law enforcement agencies to cooperate with the civilian review panel, that any documents that they would likely need to receive from the law enforcement agencies they have oversight for, they wouldn't need a subpoena because it's required cooperation. So anything else would be requiring subpoenas for people who are outside of those entities that have oversight, which would probably rise to the level of some sort of formal process. And that's why I think it was created for having a hearing. We could obviously, that could be amended, but I think that was to explain it, that is why I think it was set up at the hearing level, because and we can eliminate the hearing level so that the third party can always go to the circuit court to quash the subpoena, because you do want to build that in there. But that's why it was built in, that way. Certainly that could easily be amended, though. I think the second point you were that may have been asked was more dealing with the mandate and how we kind of square the mandate with the localities kind of organically growing this on its own, as I think one of the witnesses kind of described it as. And I'm not quite certain those two things square with each other. It's difficult to say every locality shall create a CSB when if a locality does not want to have a CSB or civilian review panel, what that panel, how that panel would act and how that panel would essentially perform its duties. And I think that was kind of the intent in putting this in DCJS to develop some minimum standards. I mean, long story short, I'm trying to square the two ideas, and I'm having difficult time to square them.
I think sort of the distinction between CSBs and school boards in this is that there's money attached to the CSBs. There's money attached to the school boards. There's not money attached to this. This is an unfunded mandate. I think that's my main concern with it. Let me get a few other people in there. Maybe you guys can think about how you want to handle this, but we do need to take some action on this bill. I see Delegate Price in the queue. Delegate Price?
Yes, Mr. Chairman. I guess my thought process for this is, of course, supportive of the idea, but I did want to, kind of like Delegate Bourne, ask for some feedback from some of the testimony that we heard from the patron, Leader Herring. And I just feel like there's some false choices being offered as we're trying to seek this compromise, because I understand that we want the community to have the power to shift it and make it fit. But then if we don't have, I guess, minimum standards, then those that didn't want it under a mandate might have lesser standards, and then it wouldn't work. So I wanted to see if you had some input on the role of the DCJS with some of the testimony about it needing to truly be independent of an agency that is quote unquote married to law enforcement, but also the need for us to have quality ones if we're going to mandate them in order for them to work.
Right. And what I envision, thank you, Delegate Price, what I envision and what I thought it would be is sort of minimum standards and guidance, sort of, if you will, an advisory role as these are being established. And I'm all about the power to the community, absolutely. But the community does need support in that. And because that DCJS would be that point of contact for assistance, but not DCJS dictating. So there are certainly guidelines for anything with meetings or whatever, and that's what I was envisioning. Certainly not a top down, but DCJS being supportive. So, and I definitely certainly do understand, but I think that if we don't have sort of a requirement, then what we're doing is we're allowing some Virginians not to have this, and it will be okay with the powers that be within the community. So again, DCJ is more of a support and not sort of a dictate.
Delegate Levine.
Thank you, Mr. Chairman. I have a question for council. I'm just trying to understand the parameters of what we're discussing here. We've talked a lot about the mandate. We've talked about the sheriffs. You've talked somewhat about the differences in subpoena power. Are there any other significant differences in Senator Hashmi's bill and Delegate Herring's bill to maybe the scope of what the Citizen Review Board does? I just want to make sure that everything's on the table here because there are some differences. And is there anything else that you think is a significant difference between those two pieces of legislation?
The two main differences that we haven't discussed. One deals with the way these, obviously the civilian review panels or oversight bodies are structured and who structures them. And that in Senator Hashmi's bill, it's the localities who decide what powers get implemented rather than it being DCJS. So the localities get to pick what powers they would like the panel to have. And her bill lays out what, enumerates the powers. Where in the current House substitute version, DCJS is the one who creates these powers with minimum standards and then going up to other guidelines and best practices to create, I'll say, more of a menu for the locality to choose from. So they're not necessarily enumerated. They may, in fact, be the same powers that are in Senator Hashmi's bill, but they're not enumerated. The second thing that the Senator Hashmi's bill does that the current substitute doesn't do is takes and this is where I think you can't rectify the two, but Senator Hashmi's bill would take any locality that creates a civilian review panel, that the Law Enforcement Procedural Guarantee Act would not be available for any oversight of any police officer under that civilian review panel. So if a locality decides to go down the civilian review panel road, that any law enforcement officers that are subject to the civilian review panel would no longer have the Law Enforcement Procedural Act guarantee available to them. Any of their essentially grievances would be handled by the civilian review panel, not according to the Procedural Guarantee Act.
And follow up, Mr. Chairman. So the lack of the grievances all going to civilian review board, that is in Senator Hashmi's bill and not in Leader Herring's bill?
I would say it is explicitly in Senator Hashmi's bill, because in Delegate Herring's bill, because DCJS gets to kind of create this menu, it would be up to DCJS creating it as a best practice or guideline, and then the locality choosing to kind of create that, which I'd say is similar to Senator Hashmi's, and the localities don't necessarily have to give that power. But if they do give that power, then that is what would happen.
So follow up, Mr. Chairman. I would ask council, is it true that if DCJS sets up minimum standards, that a locality can go farther under Leader Herring's bill and basically do everything that Senator Hashmi's bill does if the locality chooses to do it under Leader Herring's bill? Is that correct?
With the exception of the Law Enforcement Procedural Guarantee Act, that would be correct.
Thank you.
Delegate Coiner.
Thank you, Mr. Chair. I have a question for Leader Herring.
Delegate Coiner.
So a question in regards to, in your bill, I see where the review board is required to use best practices and standards and guidelines in their decision making, but I do not see a requirement for training of the members of the review board. My comparison would be to my own profession of law. On our review boards, if we have disciplinary actions, there are 2 lawyers on the subcommittee and a non-lawyer, and everyone has the same training as us from our background. But in terms of if you're not going to have other law enforcement professionals required to be on the review board, maybe I just missed it. I was trying to read through the substitute, if there's some minimum standard of training that's required in order to serve.
Mr. Chair, I would respond to the delegate that you're right. It's not dictated in here. It was anticipated by the DCJS guidelines, and that would be anticipated. The training would come through that sort of the requirement. But I do agree that I think there should be training, and would consider that a friendly amendment if it's so desired.
Mr. Chair, if I may respond.
Delegate Coiner.
Thank you. I did go through the powers on that were provided to the board, and I couldn't find where they had training required. It doesn't mean it isn't there. It's me trying to review the code while I'm also listening to all of you. But I didn't see where they had set up minimum training requirements for civilians. I saw for professionals, which, professional boards are a whole nother topic, but I didn't see that requirement. So I do think it would be beneficial if we believe as a body that it's important.
Okay, we've spent a considerable amount of time on this bill. This is an important bill, but I do think that we need to come to some consensus. I do sense, in listening to the questioning, that there's general support for this bill advancing. There's a
Mr. Chairman,
in the Senate, and so you want to keep the ball moving. Delegate
Mr. Chairman,
get us out of this now.
I'm going to try. I have a motion.
Gentleman stated.
I would move that we adopt a substitute, which is the Senate version. However, changing line 35 of that Senate version from may to shall, and then delete the exemption for sheriffs on lines 32 through 34.
All right. Charles, do you want to describe, Mr. Cagliago, you want to describe what Delegate Bourne just did?
Sure. So the substitute would essentially take the Senate version of this bill, make the civilian oversight bodies, civilian review boards to be mandatory, and then remove or expand the definition of law enforcement officer to include sheriffs and deputy sheriffs. So just while we have to delete lines 32 and 34, it would also require the definitions of law enforcement agency and law enforcement officer to include sheriffs and deputy sheriffs.
That's what I meant to say.
Any questions from the members? That's a motion.
I simply would ask, Leader Herring, what her views are on that amendment.
Delegate Levine.
That's my only question. I would like to know what Leader Herring.
Oh, no, I think that's, I'm happy with that. That's fine.
Delegate Price, you have a question?
Yes, Mr. Chairman, thank you for a question for council, because I'm trying to do a side-by-side comparison in my brain as well. In addition to the becoming mandate, including the sheriffs, what is the entity that would create how this board operates with this new substitute?
So with the substitute, it would still be up to the locality to create it. It would not be created by the state. There would be no state involvement. The locality would create these oversight bodies. And because Senator Hashmi's her current bill and this proposed substitute lays out the powers and duties, that it would be up to the locality to figure out which powers and duties it would like to authorize the oversight body to have.
All right, we have a motion by Delegate Bourne. Do I have a second?
Mr. Chairman, I will second that motion with the hope that, knowing through the legislative process we have a couple more bites at the apple, I would still like to have an ongoing conversation about who should be establishing or the role of locality versus state in quality control. But I second the motion.
Well, we got a second. Now, I know Delegate Leader Herring knows this process probably as well as anyone else here, and knows that this is a long way to the finish line, especially since you've got a different version in the Senate. I know Leader Herring will commit to working with the advocates. I'm not sold yet on the mandate, because I know that people in another part of our state will not do this in the right way, and that it's just there, it's just propped up, and no one will be protected the way we hope that they will. And I'd love to be proven wrong, but let's see where this takes us. And I know, because there's some strong advocates on both sides of the issue, and I think it was Kim Rolla who said that it probably wasn't fair to put their position in the no category, because I think a lot of people support where the direction that Leader Herring, you've taken this, and I appreciate your leadership in doing so. And so there's a lot of work between here and getting to the finish line. And it's a special short session, so I just coined a new term, a special short session. So with that, we've got a motion and a second. Any further discussion?
Mr. Chairman.
Yes, Delegate Wright, you were recognized.
Yes, sir. I had my hand up for some time, so I figured this is a good time for me to make a couple of statements. Number one, as you've heard, the debate about the effect it'll have on sheriff's departments. In the certain areas of the state, we're having a hard enough time recruiting and retaining police officers and sheriffs too. And this is going to place an undue burden on them. It's a mandate from the state, and there's no funds attached to it or anything. And I think it's an example of something we're trying to rush through a special session that needs a lot more debate. We've had a lot of complex issues brought forth this afternoon. And I want to make a substitute motion. But this bill be laid on the table.
All right, got a motion to lay the bill on the table. Here a second.
Second.
All right, got a second. That is non-debatable. The motion on before us is to lay the bill on the table. If you support, please vote yes.
Yes.
All right, all members have voted who are capable. Delegate Ferris, how do you vote on the motion? Delegate Ferris, are you still there? All right, clerk will close the roll. The motion fails 7-14. So we're back to the original motion of properly second. All those in favor of voting, yes. Oh, do we adopt the substitute? Do we adopt the substitute by Delegate Bourne? Why don't we do that? We have
I
proper.
move to adopt the substitute.
Second.
Delegate Bourne.
All in favor, say aye. Aye. Opposed?
Aye.
All right. Now before us is the bill as amended with a substitute. And does this doesn't go to appropriation, so it's all in favor, please vote on your electronic voting device.
There we go.
Delegate Campbell. Delegate Ferris, are you back on? All right. Clerk will close the roll. Bill reports with substitute 13A. Thank you, Leader Herring.
Thank you, Mr. Chair, members of the committee.
Let's keep moving. Let's try to move faster, please. Delegate Watts, House Bill 5093. Delegate Watts, are you there? Thank you for your patience. You are muted.
Now I think I should be on.
We've got you. Thank you. Welcome, Delegate Watts.
Great. And here I go on video. Thank you. Yes, this bill, while very far-reaching, I don't think it's anywhere near as complex, and so we should be able to move a little faster, although I've been extremely impressed since I've been on since 1 o'clock with the very serious work that is being done by this committee. Mr. Chairman, members of committee, House Bill 5093 is before you. This bill deals with the emergency powers and executive orders of the governor. Under current law, while executive orders of the governor are only enforced by a first-class misdemeanor, class 1 misdemeanor, excuse me, if the executive order so indicates. That is, however, the only enforcement that is available to the governor in his executive order. Therefore, House Bill 5093 gives very important flexibility so that we are able, regardless of the offense. It's just too heavy-handed to always have to have a criminal charge of a class 1 misdemeanor, and 5093 provides then for a up to $500 civil offense. It would be enforced just the same as a traffic ticket is currently enforced, which means it can be paid without any court appearance, although the individual can appear in court should they choose to object to or speak to the charge before them.
Thank you, Delegate Watts. Any questions for Patriot? Delegate Coiner, you have your hand raised for this bill. Delegate Wright, do you wish to be recognized, Delegate Wright?
Yeah, I think it's.
Delegate Davis.
I'm sorry, Mr. Chairman, that was last time.
That's all right, Delegate Wright. Delegate Davis.
Yes, sir. Just a question, Mr. Chairman, for the patron of the bill. And I think I understand this properly, but in the status quo, it seems that the violation of an executive order right now is punishable as a class 1 misdemeanor only where the executive order declares it as such. Any executive order that doesn't declare it as such arguably is not punishable by any fine or any punishment, it seems. if that's the case, is what you're doing basically saying that any executive order that declares it punishable by a class 1 misdemeanor for violation is as such, and any executive order that does not prescribe a penalty now has a penalty of not more than $500?
That would not be correct. The executive order would have to so indicate that violation of the executive order is punishable by a civil fine up to $500. It would have to be stipulated in the executive order.
Just one quick follow-up, Mr. Chairman, if I may.
Delegate Davis.
And Delegate, I think I understand now, and I appreciate the clarification. So any executive order that did not declare or define what a potential penalty would be would still be not subject to a monetary penalty or otherwise. Would that still be correct?
Would you please repeat your phrase again?
Yes, ma'am. So even with your bill, any executive order that did not declare what a penalty would be for violation of it would still not have a presumption of penalty associated with it. Would that still be correct?
That is correct. The same structure that the codes currently has, that the governor must indicate that violation of his executive order is punishable. Currently, he only has the choice of a class 1 misdemeanor, which could involve jail time and up to a $2,500 penalty.
Thank you.
Thank you, Delegate Davis, Delegate Watts. Okay, let's turn to the witnesses to present testimony. Rita Davis from the governor's office. Ms. Davis, are you still in the waiting room?
Good afternoon again, Mr. Chair, members of the committee. Can you hear me?
Yes, we can. Welcome, Ms. Davis.
Thank you again. The administration strongly supports this bill for the very succinct and persuasive reasons given by Delegate Watts. Thank you.
Well stated, Ms. Davis. So any questions from the committee? What's your pleasure?
Move the report.
Bill.
Got a motion properly second to report House Bill 5093. Please vote on your electronic voting device. All members voting who wish to be cast. Delegate Ferris, are you still on?
Mr. Chairman, Ferris is a no.
Ferris is a no.
Delegate Ferris votes. All members have voted, Mr. Chair.
Bill reports 19-3. Thank you, Delegate Watts.
Thank you, Mr. Chairman.
We're getting on a roll. Let's keep going like this. We got Delegate Guzman, not a member of this committee. We'd like to hear from her. 5108. Delegate Guzman.
We're bringing her in the room.
Delegate Guzman, you are muted and you are recognized. Please unmute yourself.
Okay, thank you, Mr. Chairman, members of the committee. I would like to move a substitute.
Like to move a substitute. Mr. Quagliato, do you want to describe the substitute, or can you describe the substitute, Delegate Guzman, before we move it?
Sure, I can describe the substitute, Mr. Chairman. House Bill 5108, what we're doing in the substitute is we're striking line 105 through 106, and then lines 27 through 29. Everyone should have a copy of the substitute on their email. And the reason is because those two lines are probably going to be addressed during regular session. We're still speaking with some of the stakeholders, including the administration, that we would love to work on that on a special session, Mr. Chairman. But the nature of the bill is still on, and I would like to move forward after the substitute is moved.
Well, let's go ahead and without objection, substitute is approved. Delegate Guzman, you're recognized.
Thank you, Mr. Chairman. Well, I just a little bit background of this bill. Participated in a couple of meetings, work groups, when a few delegates present today, where we have acknowledged that we need to update the membership on the Criminal Justice Services Board and the Committee on Training. I think that we have heard the public, and the public has the public has been heard. You know, there is a lot of representation from law enforcement within these boards and committees of training, but we need to just diversify that. So with that being said, you know, the current Criminal Justice Services Board has 29 members, from which 17 are gubernatorial appointments. And this bill is asking to increase that membership to 30 and increase the gubernatorial appointments to 18. So what we're going to do is we're going to keep the representative of crime victims organization or a victim of crime. We want to add 2 representatives of community of interest of the minorities, and the minorities are specified on the Code of Virginia. We make references of the part. 2 representatives of civil rights organization and 1 mental health provider. Because as we're having conversations with the stakeholders as well, we have recognized that, you know, law enforcement needs mental health support as well, as they are exposed to trauma. The second part of this bill is on lines 104 to 122, when we're talking about the Committee on Training. The current membership is 15 members. So this bill will remain, we will have still the 15 members, but what we're doing is reducing the participation of the Virginia Sheriff's Association from 2 to 1, the Virginia Association of Police of Chiefs from 2 to 1, and we are updating the membership of a community interest, saying that those community of interest should be from the minorities. We're adding 1 representative of the Virginia Indigent Defense Commission, 1 mental health service provider as well, and 1 citizen representing a civil rights organization, Mr. Chairman. And also, what I just could say to conclude, I think the governor has this bill also is appoint a curriculum. The Committee on Training will have the ability to appoint the curriculum review committees in lines 122 to 128. And we're taking this opportunity to update some of the old language on this bill, as we were referring at the Senate Committee on Finance, and we're adding Finance and Appropriations. And then it says Senate Committee for Courts of Justice. So we are putting on the Judiciary Committee, and those are on lines 75 through 79, Mr. Chairman. I think, as I was saying earlier, Governor Northam has made a priority that we change the leadership on the Criminal Justice Services Board's Training Committee. And training is the root beginning of culture in law enforcement. It's critical that the culture fostered will result in trusted, effective law enforcement officers. The committee needs to be more inclusive of different interest groups in the community that are needed to ensure a trusted, well-functioning law enforcement agency. And that would be it, Mr. Chairman. I hope it's the pleasure of this body to support this bill.
Thank you, Delegate Guzman. Delegate Will, you have a question for the patron.
Thank you, Mr. Chairman. So, looking at the purpose of the Committee on Training, with the change in the membership of that, is there any requirement standards of members on that committee? I mean, any level of training or expertise that they need to hold to be a part of that?
Mr. Chairman, I would tell Delegate Wild that the membership for Committee on Training hasn't been updated for a while. I understand there is room for more requirements, but I think sometimes change will take a few steps. And this is the first step to first update the membership, and when we could ask on requirements. I think that we all trust on the abilities of the Department of Public Safety and the governor to appoint those individuals. We're asking for a profile, but as far as the requirements, I think I hear you, Delegate Wild. We had to do it, but not just yet.
Delegate Price, you recognize.
Yes, Mr. Chairman, I just had a quick question, just so I'm understanding of either the patron or council. So who then, at this moment with the substitute, is the entity that would be considered to be in charge of COT?
I'm sorry, in charge of?
COT, in charge of the committee.
In charge of the, so Currently, under the substitute, it still remains under the board. So the board, the Committee on Training would still be under the board of DCJS.
Okay, thank you.
Okay. All right, let me go out to the witnesses. Our first is Maggie DeBoard, followed by Kelly Harris Braxton. Mr. Board.
Thank you, Chairman Hope and Vice Chair Bourne. I appreciate the opportunity to speak on behalf of the Virginia Chiefs today. I just want to make one quick point about this. We are opposing the reduction in representation, both for us and really for the Sheriff's Association. It's important that we maintain membership for a couple of reasons. We are not at all opposed with the inclusiveness of other groups. We think that may certainly add value to the things that we have to do as a result of being on both the Committee on Training and on the Criminal Justice Services Board. And this is especially important when we are looking at proposed legislation to establish standardized curriculum. That is going to be a big job to do. And police chiefs certainly, and sheriffs who are out in the field and have spent their entire lifetime in this profession, certainly understand what those standards need to be from a base level, at least, to make sure that our officers and our deputies are fully trained to do the best policing they can within their community. So taking that down is really going to reduce our input at a time when our input is going to be more greatly needed. While we have 2 police officers on there, and this applies to the Sheriff's Association as well, or police chiefs and sheriffs, is for a couple of reasons. One, police chiefs and sheriffs certainly get tied up on other crises involved in their jurisdictions at times, and having somebody not be able to make a meeting could be really detrimental to the discussions that happen. But more importantly, when we place police chiefs on these committees and on these training committees and on the board, we do so trying to represent a diverse environment. For example, we don't put 2 very populated areas or 2 from Northern Virginia. We spread it out between rural and populated areas. We also try to spread that out between large and small agencies because the needs are very, very different and the resources are very, very different between large and small agencies. So it's imperative that we maintain those spots. There is zero fiscal impact to us to maintain those positions on the training board, on the Criminal Justice Service Board, and on the training committee. We're happy to continue in that capacity. And honestly, we would look forward to having more input from the community groups as we move forward in those processes.
Thank you very much. Next speaker is Kelly Harris Braxton.
Good afternoon, Mr. Chairman, members of the committee. I'm Kelly Harris Braxton, and I am the Executive Director of Virginia First Cities Coalition, 16 cities in the Commonwealth, and we spoke a little earlier. We support strongly the concept of this bill. We believe that Virginia First Cities believes that training is a real serious concern for all officers statewide. We feel that there's a need to improve training, that there's a need to make sure that everyone's getting the training. And we do support this bill. We certainly want to have enough input, as the chief just said earlier. So that may be one sticking point, but it is certainly the training is most important. And we feel that particularly there should be a focus on issues related to bias, mental health issues. All of these things need to be part of the training that our officers are getting. And we strongly support enhanced efforts on training. So thank you.
Thank you very much. Questions for the patron? Delegate Price, do you wish to be recognized? Give your hand up.
That was from my previous question. Thank you.
All right. Seeing no hands up, committee works on motion. Oh, I think we did. Did we adopt the substitute? I think
Mr. Chair, I move we adopt the substitute.
Right. Without objection, substitute is before us.
Mr. Chair, would move to report as report the substitute.
We've got a motion.
Second.
A second, properly second. Please vote on your electronic voting board to report House Bill 5108.
Ferris is a no.
Delegate Ferris is a no. Delegate Bourne. Delegate Price. Delegate Wright. Delegate Wright.
No, no,
Repeat, please, Delegate Wright.
no, please.
Delegate Wright votes no. Mr. Chair, all members have voted.
Thank you. Bill reports with substitute 13-9. Thank you, Delegate Guzman.
Thank you, Mr. Chairman, members of the committee.
All right, let's go back to the top of the agenda with committee members. I believe we completed all the non-committee members. House Bill 5044, Delegate Davis.
Yes, sir. So 5044 is just a minimum standards for following with regards to investigations. Essentially, all it does is suggest that, excuse me one second, I'm pulling it up here myself through all the other legislation we have. Basically, that I'm sorry, there's a substitute, I forgot. I'd like to move a substitute if this is okay. It's just a 1 or 2 word substitute, Mr. Chairman.
Okay, let's go and explain the substitute really quickly before we.
Sure.
Can someone explain it, what you do?
Sure. The substitute just on lines 21 removes the term time limits and puts in procedures for an investigation, as opposed to eliminating just 2 time limits, and then puts a period after the word procedures on line 23 and strikes the rest of line 23. And staff can confirm if there's something I missed, but I think that's what it all does.
That's correct, Mr. Chairman. These were done as line amendments, which should be available shortly online on LIS.
All right, let's move the substitute without objection. The substitute is adopted.
Thank you, Mr. Chairman. So CLIA, which is the Commission on Accreditation for Law Enforcement Agencies, is a credentialing authority based in the U.S. whose primary mission is to accredit public safety agencies, namely law enforcement agencies, training academies, communication centers, and public campus public safety agencies. They were set up in 1979 and have 4 major law enforcement membership associations, including the International Association of Chiefs of Police, the National Organization of Black Law Enforcement Executives, the National Sheriff's Association, and the Police Executive Research Forum. And all this bill does is says that that the procedures for conducting an investigation of such written complaints shall be consistent with best practices, basically, of CLIA.
Delegate Price, you're recognized. You have a question?
Mr. Chairman, I apologize. I keep unraising my hand. I don't think it's reading on your end.
Oh, okay. You don't have a question. Okay, thank you, Delegate Price. We have Steve Patterson as a witness, not in the room. Okay, not there. All right, so let's. Any questions for the patron?
Mr. Chair.
I do have a question for the Delegate Rasool.
Mr. Chair, thank you. Just a question for the patron. I understand that he thinks, Mr. Chair, this is a rather simple, straightforward bill, but I'm having trouble, Delegate Davis, just trying to understand the problem we are trying to solve that we've identified here in Virginia.
Sure. So, Mr. Chairman, from what I've heard quite a bit, there's been a lot of complaints about there should be a set of standards of when there is accusations or complaints made against a police officer. How should they be handled? Who should be notified? How does should the person making the complaint, when should they be notified that their complaint's been received, and how is it moving along? How should timeframes be assessed and established for the timetable to investigate in an efficient manner? And these are all best practices that CLIA has put together. So I would tell the delegate that the problem we're trying to solve is a whole bunch of our constituents saying that there should be a set of best practices practices, there should be a set of guidelines that we hold our law enforcement to when it comes to investigating their own. And that's what CLIA set forth. And what all this does is say that we should follow these best practices throughout our police agencies around the Commonwealth.
Delegate Helmer, you recognize.
Mr. Chair, thank you. I would ask the delegate, why should we use CALEA as the standard setting, acknowledging and agreeing with the problem, why should we use CALEA as the standard setting for police investigations rather than having DCGS or the legislature itself, the General Assembly itself, define those standards? Why as a body should we accept CALEA as the investigator? Outsource this to another organization.
Sure. Well, thank you, Delegate, for the question. So, I mean, just listening to a prior conversation, there's already seems to be an issue with some members of this body with DCJS being the entity that puts all this stuff together. But because of CALEA is that national organization, it's not a state of Virginia organization. It's not a one law enforcement agency organization. It's been the agency since 1979 that a number of organizations belong to set these best practices. And in my research, it's the organization that is most equipped. It's the organization that most law enforcement agencies turn to as most credible when it comes to best practices. And Mr. Chairman, I would say that there's something else out there that we should be looking at for a set of standards. I'd be open to it, but CALEA seems to be the one that is the gold standard.
Delegate Wilt.
I'll put my hand down, Mr. Chairman. I was just getting ready to ask the delegate about the gold standard. I mean, weeks ago when we were here going through our hearings on the various issues, we heard testimony that CALEA indeed is the gold standard for the state and for the nation. And so I was going to ask him that, but he already said it. So thank you.
Thank you, Delegate Wilt. Delegate Davis, what is the standard? Is it that's currently being used throughout the Commonwealth? Is it 60 days? Is it 90 days?
Well, so there really isn't one, Mr. Chairman, and understandably so. That from a time frame perspective, it depends on the type of investigation, right? I mean, you can't put all investigations into a law enforcement officer would be 30, 60, 90 days. Some are more intense than others. What CALEA does even says that it's not the amount of time specifically. It says that agencies shall set the time frame. The time frame shall be set up front. That the person making the complaint shall be notified in a certain manner within a certain period. That their notifications, good practice or best practices, are to keep them abreast of notifications being made over certain timetables, and who gets brought into these investigations, and how to maintain transparency. So it's not just what number of days shall be allotted. It's how to run the investigation via best practices and transparency for the public.
So what is the day? What is the day standard? I know you say it's not specific. Why don't we codify that it should be up to or around 30 days or 60 days? How do we know that these things are these issues are being investigated in a prompt manner? I mean, that is the purpose of your bill, is it not?
Well, so initially, Mr. Chairman, but what I wanted was the best practices for the procedures is what I wanted in there. And it kind of included the timeline, but not the procedures. But what's important to keep is, remember, there are some investigations that very realistically that all of us would say are reasonable to assess that it may take 120 days. But Mr. Chairman, there are some that may only take 45 days. And why are we going to give an investigation for a simple issue of an investigation of a law enforcement officer 120 days when arguably it should be able to be done in 45? I don't want to put a day in because either we may limit the number of days to do a thorough investigation of an incident, or we may give too much time when we should expect them to come back sooner. What I think is the important thing, Mr. Chairman, is to ensure that an investigation is ongoing while during the process, that the proper entities and stakeholders are being notified of the continual updates, and that it's not just being shelved someplace. And I think that's what the best standards of CALEA kind of come in when they outline those procedures of how do you initiate, who should be, how the notifications come around, and then how it's conducted. And those are the things that I think are best left to best practices of those in law enforcement as opposed to some of us. But like this body has always said, it's We need to have a set of standards that our law enforcement follow. And CALEA happens to be the gold standard from what I can tell.
Yeah, no, I understand what you're saying. It's the standard. I'm not disputing that. I'm just disputing whether or not this is the proper way to solve this problem. Should we codify a certain amount of days? And I would like to know what's happening more in Virginia and what's happening in other states and what standards change.
Right.
Maybe it's something that we can work on in the off season, and maybe we can bring a bill in 2021 to figure out to get this right.
Right, Mr. Chairman, I would tell you that I agree standards change, which is like CALEA is amended over time to continue to keep up with best practices. I would mention that I can definitely understand that you may want an exact time frame for an investigation. I think, like you mentioned, that may take a lot longer to have that discussion. That's not the intent of this legislation as it's drafted right now. But right now in the Commonwealth of Virginia, there is not a set of standards that we say shall be followed when it comes to investigations. The citizens around the Commonwealth have made it clear that they want to be able to hold our law enforcement officers accountable. And the first thing in holding someone accountable is having a set of standards to hold them accountable to. And therefore, that's why we put forward CALEA as the best practice, is to hold them accountable to. And if we want to change it in 21 or 22, we can do so as well.
Delegate Levine.
Thank you, Mr. Chairman. Speaking to the measure.
Delegate Levine.
I'm reluctant in general to tie Virginia to any national agency. I actually do trust DCJS. I think they generally do a good job. And I think DCJS should look at these accreditation standards and absolutely will. But to say that if some national agency changes its standards, in June after our session, that changes automatically for all of Virginia. We just sort of go wherever they go. I don't really like to put in our code something that specifically says that some national agency changes the standards as we go along. If CALEA changes its standards and Virginia wants to copy those standards, or DCJS wants to copy them, that makes sense to me. But I guess I don't really like the idea that Virginia standards automatically get changed by a national organization. So I will reluctantly oppose this for now. Maybe it could be fixed in the future.
Did you have a motion, Delegate Levine?
I would move we table this. Gently lay it on the table.
Got a motion to gently lay the bill on the table? There a second?
Second.
Got a second, properly second. This is not debatable. Please vote on your electronic voting board to table the bill. Vote aye.
Delegate Ferris,
No. Delegate Ferris is a no.
Delegate Ferris votes no. Mr. Chair, all members have voted.
Great. Bill lays on the table 13-9. Thank you, Delegate Davis. Delegate 5049.
Yes, Mr. Chair, fellow members of the committee, here to talk about HB 5049, which is the best, we'll call it the Best Equipment for Law Enforcement Act. Providing military equipment, including the federal 1033 program to local police forces, has no proven record of making officers or communities safer. In fact, research shows that there is a significant correlation between use of the program and harm by police to civilians, diminished safety for police, and that it has no impact on crime. In addition, it's currently legal for police in Virginia to use chemical weapons against Virginia civilians that we don't even allow our troops to use in war zones, and also to use kinetic impact rounds, which are known to pose significant risk of both death and permanent disability. Police ought to have the equipment available to them that is most likely to protect both them and the public. HB 5049 ensures officer safety, the safety of the public, and continued protection from crime by ensuring our police are properly equipped to conduct community policing as partners with the public, rather than creating barriers between the public and law enforcement or leaving elements of the public feeling as though they are the enemy. It ensures that police maintain access to needed PPE, personal protective equipment, naloxone, which is used to treat opioid overdoses, and other equipment that will directly help keep Virginians safe. 5049 provides that weapons suited for a war zone are not available for general policing, with limited exceptions for tactical units. It also limits the less than lethal weaponry to those armaments that are suited for use in a civil population and are not likely to result in death or serious injury of civilians, while prohibiting our police from using weaponry on Virginians that we don't even allow our troops to use in war. With that, Mr. Chair, I welcome questions from fellow
Thank you,
members.
Delegate Helmer. Delegate Ferris, do you have a question? Delegate Ferris?
Yes, sir, Mr. Chairman. I'd like to speak to the measure, but I guess I want to know: did you get the pictures? Were you available to share the pictures that I sent to LIS?
I think they do have them. Yeah. Let me turn to Delegate Will. I'll see
Okay.
if Troy's working on it. Delegate Will?
Thank you, Mr. Chairman. Just in the description, there are a couple questions. So what we're saying is, or what's being proposed is that there will be a ban on vehicles that are mine resistant and ambush protected. That's my first question.
Mr. Chair, I would answer the delegate that the bill prohibits the use of mine-resistant vehicles that are configured for combat. It would have no bearing on such commonly used police vehicles as Bearcats.
Second question, Mr. Chairman.
Delegate Will.
Delegate Ferris, I think you're on. I think you're not muted.
Thank you, Mr. Chairman. So then also the delegate in the talking about the bill mentioned kinetic energy munitions. I would ask the delegate, what are the purpose of kinetic energy munitions? What are their purpose? They're in existence. What are they for?
Mr. Chair, I'd answer the delegate that kinetic impact rounds defined, which is part of the group of munitions defined as kinetic energy munitions within the context of the bill, are a method of launching a projectile out of a weapon that is less lethal than a bullet. In about 3% of cases, those by research, about 3% of those hit by kinetic impact projectile die. About 15% suffer a permanent disability, but they are less lethal than being hit by a bullet that is not configured to be a kinetic impact round.
Delegate Ferris, I think we have your pictures that we can throw up on the screen. All right, I see them now. Delegate Ferris. You're on mute, sir.
How about now?
I got you.
How about now?
We got
All
you.
right. I mute myself, and then y'all unmute me, and then I mute myself back. But anyhow, the pictures that I gave you, I sent to several of you, and I really appreciate getting those for the committee to look at. You'll see there, it's the pictures I sent are circled, highlighted there. We just heard that there was no proof that they saved law enforcement's lives or did anything to benefit the community. Sam Green is not sure if he's a sergeant or captain now in the Campbell County Sheriff's Department. He begged to differ. That is Lynchburg's armored car that Campbell County used at a scene where there's a gentleman in a storage unit in his backyard in a community of single wides and double wides. The bullet that hit that armored car certainly would have done a lot of damage to one of those houses. But luckily that law enforcement was getting in the back of that unit, and that's where you can see where he shot that door that Mr. Green was standing behind. We'd love to have one in Campbell County. They were able to defuse that situation where they might would have had to use some kind of chemical or something to get that guy out of that building and get him to quit shooting at his at the police and at his house that his the family members he was having an argument with. And I would just hope that the committee would take heed at what we're doing here by not allowing these police departments to defend themselves when they're defending and protecting us.
Thank you, Delegate Ferris. Delegate Rush.
Thank you, Mr. Chairman. I have a question for the patron.
You recognize Delegate Rush.
Thank you, Mr. Chairman. Delegate Helmer, are there other states that have passed a similar law? And if you know, could you give us an example of a couple states?
Mr. Chair, I'd answer the delegate that there are a number of states that have passed similar laws, including Oregon. There are multiple states that have actually put measures to limit the use of the 1055 program. There are multiple states that look at what are the 1033 program. There are multiple states that have put restrictions on the types and equipments of vehicles and other armaments that you can get through the 1033 program. And certainly that there are large numbers of bodies of law, including our own, that put limits on the types of force that can be used by police.
So I get Oregon's the only one you can tell the committee about, or?
No, you have a number of states in the Northeast as well. You have a number of states on the West Coast, so there are quite a few.
Mr. Chairman?
Delegate Lopez, can you check?
I would just, I could also help answer the question. Montana has, I think, the best version of this legislation, I think, which is what, and which they've worked on, which I think this legislation was modeled after.
A bunch of liberals in Montana. Delegate Rasool.
Thank you, Mr. Chairman. Question for the patron. Mr. Chairman, I would ask the patron, as he, in his conversations with law enforcement, because I believe he's done a great job of reaching out and doing his best to integrate some compromises, which include making sure that certain tactical units do have access to critical infrastructure. Have you heard any statistics or even large numbers of anecdotes where this type of equipment helped to keep Virginians safer?
Mr. Chair, I would answer the delegate that there are not large numbers of anecdotes where, certainly not data, that shows this equipment held broadly by police forces keeps our communities safer. In fact, there is a lot of data that shows that access to this equipment is more likely to exacerbate tensions between the community and police than it is to preserve them. In fact, it's something that if you were to look to such a bastion of liberalism as the U.S. Army, you would find. For the military police themselves say that it is not the weapons that are carried by the police, but working relationships. This is from their manual. Working relationships between commanders and protest group leaders that are the best means for preventing bad outcomes. It says that the purpose of being in civil dissent is not to impose punishment or suppress peaceful dissent, and frankly counsels the minimal use of force because more than its use can be detrimental to the mission's success. And so, in fact, among professionals, there is a widespread recognition that using excessive force is more likely to exacerbate than to make and frankly, to having these weapons that separate the police from the population that they are part of is more likely to inflame tensions than it is to decrease them, and thereby increase risk both to the police and to the public.
Let me speak of the public. Let me go ahead and turn to the public here. Seema Sked.
Hello, can y'all hear and see me?
Hi, Ms. Sked. We can see you. Great. Thank you. Welcome.
Okay.
Thank you. I am in support of HB 5049, which would prevent law enforcement agencies from acquiring military weapons or property. Military weapons are meant for war, not for daily policing. I'm extremely against a militarized police force. These weapons are used to intimidate and harm civilians on a regular basis, especially when we exercise our right to free speech. We have endured tear gas, pepper spray, flashbangs, rubber bullets, and more. Officers have semi-automatic weapons attached to them. There are airplanes circling above our heads. They're armored vehicles. And tear gas, as you know, is banned in war, so why do you keep using it? Why do you even have it? When people talk about not having funding for this, that, or the other, this is what funding is being wasted on. If we don't purchase these items, we can clear up a lot of money for education, for housing, for schooling, for healthcare for people, and that's what's important, not somebody having a tank. Y'all need to stop playing dress up, and this is not a video game. This is real life, and you are hurting us. So stop.
Thank you, Ms. Gad. Next speaker is Maggie DeBoard.
Thank you, Chairman Hope. This is Chief Maggie DeBoard again from Herndon. You know, I have to say I respectfully have to disagree with many of the comments that have been made regarding this bill. We do, as I represent the Virginia Chiefs, we do not oppose the ban on tanks and those types of large-scale military type equipment that obviously has been open for agencies to acquire in the past. The agencies that do need to have those typically will purchase those, the armored vehicles and stuff, through the right things. The one issue, though, that we do have issues with is the ban on the use of, or the fact that we can't obtain rifles through this program. And I will tell you that, you know, the militarization of the police is certainly a big discussion, and de-escalation and all the right things have to happen so we don't get into a bad place. But sometimes violence occurs, and it occurs very suddenly. And you do have a waiver in there for special weapons and tactics teams, which is great. But the people who need to have those rifles are your patrol officers, because if you have an active shooter anywhere in the Commonwealth, there is zero time to get a special weapons and tactics team to that scene. Patrol officers have to be equipped with rifles to readily respond and end the incident as quickly as possible. And currently, if an officer does not have a rifle, they have zero ability to protect themselves. They have zero ability to protect any of the community if somebody is shooting off a rifle. The armored plates that we wear in our vests and our shields do not protect us from rifle fire. So we need the ability to quickly end an encounter if a rifle is being used. Large agencies, and I do speak from experience, I spent the majority of my time in a large agency, and now I'm in a mid-sized agency, which is really considered small up here in Northern Virginia. And I will tell you that a lot of smaller agencies or mid-sized agencies do not have the funding to purchase these for their agencies. They do need to be in the hands of patrol officers, and many of the smaller mid-sized agencies also do not have trained tactical teams. So making a waiver for the SWAT teams is great, but it does not go to the need of where we are with that. The other thing that I have a real heartache with, and again, I want to say that I do respect the input that's been given today, but I really have to disagree with the kinetic weapons. And I believe, and I'm making an assumption here, that this was put in here because of the use of these munitions in civil disturbance. And the last speaker from the community just spoke about the concern with that, about using during peaceful protests. We don't advocate that whatsoever. We believe peaceful means peaceful. But the way these weapons, these munitions are used on a regular basis throughout the Commonwealth is not in civil disturbance. I spent 4 years commanding a SWAT team with the largest agency in this state, and I can tell you those munitions have saved lives. We use them when we can't get close enough to use a taser. We use them when we have to have a standoff distance from somebody who is armed with something other than a firearm, let's say a knife, in close quarters in a hotel room. Typically, they are used from a position where they are not visible, and they are used to create impact on that person to get them to drop that weapon so that they can safely be taken into custody, whether they are committing a criminal act or whether they are in emotional crisis. I have seen them used countless numbers of times. They are readily available in all the patrol cars throughout this county here, in many other counties throughout the Commonwealth, and taking those munitions away will only lead to more police shootings. I have zero doubt that some of the incidents that I have been personally involved in or have seen would have led to police shootings without use of those kinetic weapons. And they did not end up in permanent injuries. They ended up, the ones that I have been involved in some minor injuries, some severe, but they all recovered from those injuries. This could be devastating to our desire, I think, your desire and ours, to minimize those number of deadly force encounters we have throughout this Commonwealth. We have to have access to those less lethal weapons. I will add a reasonable stipulation with this would be maybe to restrict the use of those in certain types of civil disorders, or get permission to use them in certain types of planned civil disorders that may arise, but to take them out of our daily availability for less lethal to use in crisis situations that occur without notice on the street on a regular basis would be devastating to our profession.
Thank you very much, Chief. All right, questions for the patron, Delegate Wright.
Thank you, Mr. Chairman. I served previous to you as chair of the Public Safety Committee, and I congratulate you on the good job you're doing. I'm kind of really saddened to see the direction we're heading in. When I was the chairman of the Public Safety Committee, we was told that the citizens didn't need to protect themselves as much. We needed to cut back on the types of weapons and the number of bullets in the clips and so forth. Now they're saying the police don't need these to have enhanced weapons. Well, in the past, if my memory is correct, then police had to have better weapons because the criminals and the ones that they were sent out to protect us from were outgunning the police. I can't imagine anything that would help a police officer defend a community and to promote law and order to be objectionable. And everything that's mentioned that they now have, it's been testified to by police officers. I've got emails right here before me I could read, but in the presence of time, I will not do so. But I think it's something we need to think very carefully about, and also the morale of the police. I'm getting emails on those too. I mean, they're out here fighting for us. The ones not only involved in riots and civil disturbances in some areas. We're fortunate in my part of the state, we don't have those types of things. But when we're talking about taking away the civil immunities, talking about taking away and creating career civilian review boards, all these sorts of things are taking a toll on the police officers. And I think we need to think very carefully about it. Thank you very much, Mr. Chairman.
Thank you, Delegate Wright. Thank you for your kind words. Delegate Cole.
Thank you, Mr. Chair. Speaking to the bill.
Delegate Cole, you're recognized.
Thank you, Mr. Chair. I think that, and I don't want to be presumptuous, but I think I'm the only one of the members who are on this committee today that have observed up close and personal and actually experienced the use of force by police officers during this protesting season. Back on March the 31st, there were some protests that were peaceful in the city of Fredericksburg. They started off peaceful and there were plenty of protesters. And then as nighttime came, there were some interactions with the police officers. And I received a phone call from a parent who was concerned about her child. So I went downtown Fredericksburg to see if I could find them and to get them home. Well, while I was getting down there, and I had asked students and young people who were there to get home as expeditious as possible, in the middle of me talking to a group of students, without any problems, without any issues, we were tear gassed. My back was to the police officers, and students and protesters were leaving away. And as we were leaving away, we were tear gassed. There's another video that is circulating online now where a young lady who was standing with her hands up with a sign, they shot a tear gas canister at her. It hit her in her stomach, and she was tear gassed. Now, what I want us to consider is, I understand what you're saying about being protection and different things like that for those who are posing threats, but what about situations and circumstances where you have peaceful protesters who have no weapons, who are posing no threats, but they become increasing more as soon as a Bearcat rolls into town, as soon as the riot gear steps onto the street, It has been proven time and time again that the usage of these visages, the uses of these weapons, causes the crowds to go increasingly more aggravated. And if our police officers are supposed to be leading and protecting and serving, we have to find other measures of doing crowd control without intimidating and enforcing people this way. And so I'm asking that my colleagues would support this bill today, because we have to find another way to deal with this. And as someone who was directly affected by this, I'm telling you right now, this is not the way that we should be dealing with crowd control.
Thank you. I neglected to call on Phil Thompson, who's been waiting in the queue to speak. Mr. Thompson, are you available?
I am. Can you hear me?
Yes, sir. We can. Welcome. Thank you.
Thank you. Not sure why my camera's not started, but I sort of want to disagree with the chief and say that, you know, when the officer was on George Floyd's neck, that wasn't a police procedure, but he did it anyway.
Would you identify yourself, Mr. Thompson? Are you with the group?
Yes, I'm former NAACP President Loudon, former state NAACP Criminal Justice Chair. I'm on the board of the ACLU, President of Diverse Engagement, but I'm not representing the ACLU or the NAACP.
Okay. Thank you. Go ahead.
But I want to say that this is very, you know, with what the chief said with regard to having all these weapon systems in place can help, but they get abused. And as the delegate just explained to you, it also did. I'm also a retired Marine Corps officer. And as you see law enforcement is every day that you see them more militarized, and this impacts an attitude among law enforcement. When you start carrying all those weapons and you start to have all the ability to use those weapons, it causes a problem with regard to the mentality that you start to get. And that's the concern that a lot of citizens have with law enforcement, where when my uncle was a police officer for a long time in St. Louis, all he had was a .38 and a shotgun, not an assault weapon. I myself have seen, even in my neighborhood, which is a gated community in Loudon, where there's a complaint of something, the officer shows up with the assault weapon out. I had to run back in my house because I was the only black guy out there and I didn't want to be the incident. But my point being is that these type of weapons and use of military weapons bring on military tactics, and military is designed to come in, occupy, take control, and do what the military does. The more the police get these weapon systems from the military, they start to take on that mindset, and we lose the ability to have what we call community police, because now because of the way they're armed and the way their tactics are changed, because the arming changes the tactics, which before where there was de-escalation, now it's I got these weapons, I'm going to show who I am and what we are, and we're going to control this situation, and that causes more and more problems. So this bill, I believe, is a start toward a bigger conversation on how our police are becoming more of military forces and not law enforcement, protect and serve instead of occupy and control. Thank you.
Thank you, Mr. Thompson. Delegate Price, I'm going to give you the last word.
Yes, thank you, Mr. Chairman. I just wanted to remind the committee and the public about some testimony that we heard during the joint committee meetings. And so I will be supporting this bill, but as a piece of what militarized policing is. And so understanding that equipment is one piece, culture and tactics and professionalism and organization were the others. And so I do look forward to supporting this, but as a piece of reforming how we get rid of militarized policing in the Commonwealth.
Do you have a motion, Delegate Price?
First off, Mr. Chairman, is the patron allowed to speak to this bill, the last word on this bill?
If he insists. Delegate Helmer, would you like a last word?
Mr. Chair, I do not insist.
Delegate Price, you have a motion?
Yes,
refer to appropriations. I got a
that is my motion, sir.
All right, got a motion. Is there a second?
Second.
Motion properly seconded. Please vote on the electronic.
Mr. Chairman.
Delegate Wright, please restore the roll.
Substitute motion, please.
Substitute motion. Delegate Wright, you'll state it.
Yes, sir.
State your motion.
Because of the debate we've had today and the apparent need for more information and so forth, I'll make the motion that this bill be laid on the table.
Delegate Wright makes a superior motion to lay the bill on the table. Is there a second?
Second.
Properly second. Please vote on the electronic voting board. Vote aye to lay the bill on the table.
Delegate Ferris. Delegate Ferris.
All right, clerk will close the roll. Bill fails, motion fails 8-13. All right, so we're back to the original motion to report and refer to appropriation. Properly second, please vote on the electronic voting board. Delegate Ferris, do you wish to vote? Cast your vote. All right, I don't hear him. Bill reports and refers 13-8. All right, a few more bills left. I think we can move quickly. I hope we can. House Bill 5076, Delegate Coiner.
Thank you, Mr. Chair. House Bill 5076 makes changes to the minimum qualifications. I added 5 simple words. Currently today, our law states that if you want to go into law enforcement, you have to have a perfect past. We require that you have absolutely no misdemeanors on your record. And after having listening sessions with leaders within our Black community and in my district, and in meeting with our sheriff, we talked about how difficult it is to recruit candidates. One of the things that was brought up was that with disparate policing and looking at how many members in our community who are minorities who do have misdemeanors on their record, we really block out a whole group of people that because of something that may have happened when they're 18 years old, a shoplifting charge, and then they no longer make those poor choices when they were younger, that all of a sudden, as an adult, a mature adult, we have completely blocked them out of their ability to qualify, to even be reviewed. So the current state law makes it where you cannot even be considered. The change that I added would allow for misdemeanors like shoplifting for our sheriffs, for our police chiefs to be able to consider that, but it doesn't automatically disqualify people in our community who may have made a poor decision in their past on a minor issue and it impact them later on. It does still provide that if you had that misdemeanor within 3 years of looking at that review, that it would be an automatic disqualifier, just so they have some ability to take out applicants that it was an issue that came up very recently. So our goal is that we increase the number of folks in the applicant pool. My community felt like it would increase the ability for men in particular in our community who have maybe not qualified for law enforcement but are interested to have that opportunity. So this is really a result of listening sessions that I held in my district, and I would be happy to answer questions at the committee.
Thank you, Delegate Corner. I'm going to go directly to the public. Sheriff Leonard. Would you please unmute, Sheriff?
Good afternoon, Mr. Chair, members of the committee. I appreciate your time, and I understand we're running late, so I'll be quick. I am in support of House Bill 5076. I think we have been hampered by the old existing regulations for some time. We are trying to create a bigger pool of candidates, a more diverse pool of candidates for employment with sheriff's offices, troopers, and police. And I personally have had situations where somebody who may have had a minor indiscretion as a senior in high school, age 18, where they might have shoplifted and now become ineligible for life to become a police officer or a sheriff. I know of another incident where somebody stole a shopping cart at a young age. And, this opportunity here now is for redemption. It gets them past that. After 3 years, they can now come back into law enforcement and get that gainful employment. And we just want to increase our pool of candidates, and I would support this bill.
I'm muted. Eric Smith, are you here? Mr. Smith?
I am. Thank you, Mr. Chair.
Welcome.
I'm Eric Smith with the Department of Criminal Justice Services. The administration does not have a position on this bill. However, I would like to note that one of the concerns that has been expressed through some of the other proposed legislation involves the creation of Brady lists. And these misdemeanor convictions of moral turpitude, such as petty larceny, would still be matters that would get a potential officer placed on a Brady list. Those convictions don't expire for those purposes. So that would still be something that would have to be disclosed in any court case that the officer would testify in.
All right, thank you. Next is Alan Charles Chipman. Chipman, are you still with us?
Yeah, I'll be brief. That was exactly my concern. The concern of what that would do to the records that's required for police report that have been involved in such misdemeanors as that. And so that was just echoing what was just said, and I know we're short on time, so I'll.
Thank you. Thank you, Mr. Chipman. Thank you for your testimony. Delegate Davis, you're recognized. You have a question for the patron?
Sorry, Mr. Chairman. I was so used to leaving mine up for the whole time we were discussing Delegate Helmer's bill, I forgot I needed to come down when I wasn't called on. Sorry.
That's all right, Delegate Davis. Never can hear too much of you. Delegate Price.
Yes, Mr. Chairman. I completely, you just don't even know, I completely appreciate how it seems to be that we are acknowledging the impact of mass incarceration on the African American community. And so I just want to pause and say that this is pretty significant. My concern is, while having heard from law enforcement on the reasons why there may not be as many African American candidates or applicants for policing, is a very, very different reason here in Newport News. It is the relationship between the community and law enforcement needing to be improved. So because I had not heard this before, I would like to look at this further, but be able to get more input from my community, not so much from the law enforcement side, but from the community, because I do believe that there is a scenario where there might be someone that grew up in a church and is in the community and has maybe made a mistake, and there's forgiveness amongst the community because they know them, they know their heart. But then I am wondering about some of the pushback about the hiring practices that we currently have, and when people from outside of the community are coming in, and those are often the ones that are breaking the relationship between law enforcement and community. And so if we're relaxing standards for them, that is where I would like to check with my community, specifically speaking the 95th district, not just the African American members of it, but the 95th district. And so I would want to see with Mr. Chairman, if there was any way that we could take this up in 2021, because I agree with the merits, but just wanting to check in with more of the community.
Let me ask the clerk, can you continue a bill until 2021? Not from special session. So the only appropriate motion would be to lay it on the table, but with a commitment that we could work on it in the off season. And perhaps we could hold a hearing where the committee is empowered to hold hearings, subcommittees are. And so perhaps our public safety subcommittee chairman might be interested in Delegate Levine. He's a softie. You might be able to work with him and have a hearing on this matter.
I'd be
I agree the concept is a good one and certainly move in the right direction.
Mr. Chair, may I speak to that?
Yes, Delegate Corner.
I did have two members of the Black community in our district who actually spoke at our joint committee meetings on behalf of several of my colleagues across the aisle's bills. Dennis Parker had been on since 1 p.m. to speak. And like most people in the mental health profession, he had to go and attend to something else, as well as Vernon Oliver, who had been participating. So this was an issue. While it doesn't solve all recruitment for qualifications for diversity, we do know it is a big piece of the puzzle. And while we have momentum around focusing on these issues related to justice and increasing our diversity in candidates, I would respectfully request we perhaps not consider tabling it and continue moving forward. I completely agree with Delegate Price that it is about relationships and trust, and you apply for jobs in places where you feel like you can serve and trust people. And what I will say, what my Black community said was, when they've made a mistake and then they have moved forward, we often use them in law enforcement to take them around to churches and youth events for them to laud how they've made a change in their own life. And our law enforcement has them come alongside them and try to encourage our youth to make better choices. But then we tell those same people that our sheriffs and police take around to encourage our youth to make better choices, and we flat out tell them, you cannot serve with us. You can come and be motivational and speak, but you can't serve with us. And so this doesn't require that you hire them, anyone who has a misdemeanor. It just simply makes it where they get a fair shot to be reviewed for law enforcement. It just simply gives you a fair shot. So I wish that the gentlemen who were on the line, they sat for hours waiting, could have expressed from our community, because I think it would address some of the concerns that not just law enforcement supported this. This really came from my community's listening session that our sheriff agreed to come to with me to hear what our community felt was needed.
Yeah. No, thank you for that. Delegate Price, did you want to respond?
Yeah, I did want to respond with a motion and just redoubling down on my commitment, just on the committee where I serve with behavioral health, that we are looking into barrier crimes and how to get more people into the workforce. I just want more input, because no African American community can be owned or is monolithic. And so I think that we would love to have the opportunity to speak with whether it's Delegate Levine or whatever the mechanism may be, but to definitely have more input on this. And so my motion would be to lay it gently on the table with a public commitment to working with the delegate to see where we can get with this.
Got a motion to lay the bill on the table. Is there a second?
Second.
Got a motion to lay the bill on the table, properly second. This bill is not debatable, that motion. So please vote on your electronic voting board to lay the bill on the table. Vote aye if you want to lay it on the table.
Delegate Ferris,
No, I do not want to lay it on the table.
Delegate Ferris votes no. Mr. Chair, all members have voted.
Thank you. Clerk, close the roll. Bill is laid on the table 13-9. Delegate Coiner, Delegate Price, please get with Delegate Levine about perhaps a subcommittee hearing in the off season. You can bring all the stakeholders together, law enforcement and witnesses, public witnesses, to talk about this idea. Thank you. Next up, Delegate Price, House Bill 5104.
Yes, Mr. Chairman, I have 2 line amendments that have been released, and I'd love for council to report those at this time, please.
Mr. Quagliato. Mr. Quagliato, would you report the line amendments?
There are 4 amendments. So the amendments are on line 23, after the word Commonwealth, we're striking the and. On second amendment is on line 21, after least strike, this is the technical one, strike 18, the word, and replace it with 18, the numbers. On line 25, after satisfaction, insert semicolon and Roman numeral 9, undergo a psychological examination subsequent to a conditional offer of employment conducted under the supervision of a licensed psychologist or other licensed mental health professional. And the fourth one is on line 44, after 2, insert such officers or deputy sheriff's resignation.
All right, can I, without objection, let's approve those line amendments without objection, so ordered. Delegate Price.
Yes, thank you, Mr. Chairman. Mr. Chairman and members of the committee, House Bill 5104 is definitely offered in part of a larger package of the bills that we're hearing here and in courts intended for the larger reforms. But one of the issues that has been raised in conversations over the last couple of years has been the inability of police department chiefs and sheriffs not being able to get a full picture of an applicant that might be being applied to be hired for their department. And so before they're deciding, who should be on their department, it has been the consensus that they should have the most information. And one of the things that we did here a few years back was that city attorneys were counseling some of the police department chiefs to exercise extreme caution with regard to this code section, and has resulted in a lot of chiefs' inability to be able to fully vet someone prior to the hiring process. And so what these including these amendments really help for the prevention of a potentially bad officer to jump from department to department without these full conversations happening amongst the chiefs. And so House Bill 5104 seeks to clarify how this process should go if a department does receive an application from someone who has previously served as a law enforcement officer within the Commonwealth. And so as of now, for example, if an officer is fired for excessive use of force, from my understanding, that is not currently covered under what the chiefs can discuss as they are being counseled. So if they were also fired for a racist or sexist Facebook post or culture that might not fit with the desire of the department to be the best of the best, that is also not covered. So this would mandate a psychological exam, which I know is in another bill that's being hired, but it would put it in this it would put it in this code section. It mandates that the communication about this information must occur prior to being hired. It expands and clarifies what the communication can include, and clarifies the department has immunity unless the information was disclosed that was knowingly false or deliberately misleading. And so that is the bill, Mr. Chairman and committee, and that is the reason behind and the rationale behind it. And I can answer any questions.
Yeah, I'm going to go ahead and turn to the public, and there's no one in opposition to the bill that's signed up to speak. So I think that's good, Delegate Price. But I'm going to limit the testimony to 5 minutes because we are running late on time. Craig Wheeler, followed by Eric Smith. Could you come testify, but please keep your comments brief?
Yes, Mr. Chairman. Good afternoon. This is Craig Wheeler. Good afternoon as well to the members of the committee. Again, I'm Craig Wheeler from Richmond-based SOCH, and I'm proud to say that several of the Commonwealth's agencies in each city and county utilize some form of our software to streamline their most critical processes. For the record, again, I'm not speaking in favor or against this bill, but rather providing comment and posing a few questions for the committee. Thank you for the opportunity to comment on HB 5104, specifically regarding its provisions pertaining to the disclosure and availability of information from one law enforcement department to another. And should this legislation become law, the technology already exists to balance the privacy and public safety concerns that are inherent in such a software platform that would be utilized throughout the Commonwealth. The three questions for the committee, and I'm sorry I didn't start my video here. I apologize for that, everybody. Here I am. Good afternoon. But the three questions I have for the committee to consider: how far back would records go? How many years back? And what type of software system is envisioned for such a system? It would have to be really comprehensive, obviously. And then the final question I would pose to the committee to consider is, would the law require the data stored in the system to be stored in Virginia to ensure the privacy and security of that data? Thank you.
Did you want to respond at all, Delegate Price? Maybe after.
Yes, that is definitely something that we can look into, but the chiefs that I was talking with would simply like to be able to discuss this even over a phone call. That is not even allowed based off how they've been counseled, or the fact of them being able to go to the actual department and read the files themselves.
Okay. Eric Smith, followed by Douglas Goodman.
Thank you, Mr. Chair. Again, Eric Smith, Department of Criminal Justice Services, just stating that the administration supports the concept of making sure that all hiring agencies have complete or as much information as they can have about prospective employees. Thank you.
Thank you. Douglas Goodman.
Mr. Chairman, thank you very much. It's been a long afternoon. I appreciate you allowing me the time to speak.
Of course.
Just a few points, and the first point, we are in support of this bill from the Virginia Association of Chiefs of Police. The more information we can garner on applicants, the better decisions we can make for our communities. One word of caution, and that is just a capacity caution on the requirement for psychological evaluations, which I personally support and do in my own agency, is that there are very few certified police psychologists in the state of Virginia. So there may be some backlogs, if you will, or maybe a funnel point if this passes, to get officers through those psychological exams. So we may have to look at some language that allows for something other than a certified police examiner, or maybe a delayed implementation that allows the market to catch up with the need, if you will. And I'm happy to talk with the patron more about that. The second issue that I would like to bring up is on line 36 of the original bill that I pulled off, and it talks about shall request from prior employing agencies. All that we would like to ask is to ensure that we're not held accountable to employing agencies that were not made known to us by the applicant, or that we can find out through other means through DCJS. If we know who the employing agencies are, yes, absolutely, we need to check with those past employing agencies. And the third point, and then this is just more the mechanics, and again, this kind of goes to what the patron discussed with city and county and municipal attorneys, is this is allowing for that conversation to be held between chiefs or background investigators subsequent to a conditional offer of employment. I will tell you that in my own process and in many processes of other chiefs that I know, the only two elements that are usually employed after a conditional offer of employment is the psychological exam and a medical and drug screen. So essentially, once we issue that conditional offer of employment, the only way to rescind that offer of employment is with a failed psychological, medical, or drug screen. So we would just like to have the flexibility to be able to request this information even prior to the conditional offer of employment, and maybe the language that could be substituted is with a signed release from the candidate who is interested in seeking the position. I'm happy to answer any questions you may have, sir.
Thank you. Let me turn to the committee. Delegate Wilt, questions? The patron.
Thank you, Mr. Chairman. Yes, the question I have is on the expunged information language. We hear, quite a bit being made lately of expunging folks' records and so forth, but yet here that's being required to be reported. And so to me, it seems so counterintuitive to the whole thing of wanting records to be expunged, but yet here it's been expected to be revealed, and whatever you want to call it. Is that even a question? Why? But then, is it even legal?
Mr. Chairman, I can answer to one part of that, but then I would ask for council's assistance on the second part. The first part is, I think another, I don't want to just pull out one piece of the messages that this entire package of bills is sending. And so while I am 100% in support of second chances, I am also in support of raising the bar and the bar for excellence and the minimum standards for which our law enforcement community is being held. And so I think those two things can be simultaneous. But as to the legality, I have been working with law enforcement and lawyers on this for quite a while, but I will let a lawyer answer that question.
Mr. Chair, what I would say is, had this language not been in the bill, that practice would be something that would be prohibited by law. But since the bill explicitly allows such disclosure, it does make it permissible.
Thank you, Charles. Are there other questions for the patron? All right, committee works on motion.
Move to report and refer. I believe that's a proper motion, Mr. Chairman.
That is correct. We got a proper motion, report and refer to appropriations with amendments. Please vote on your electronic voting device.
Delegate Ferris. Mr. Chair, all members have voted.
All right, bill reports and refers to appropriations 13 to 8 with 1 abstention. Thank you. Last bill is my bill, and I'll turn it over to Vice Chair Dorn to chair this last one. House Bill 5109.
Thank you, Mr. Chairman. Next up, committee members and public, we have House Bill 5109, chaired by our illustrious chairman, Delegate Hope. So, Delegate Hope.
Thank you, Delegate Mr. Chairman. Charles, you have a line amendment. Do you want to go ahead and report that?
Yes, Mr. Chair. It's just a technical amendment that on line 279 after officers, you would strike the remainder of that line and up to include on line 280 and insert in the following subjects. And basically the purpose is, as I said, purely technical, but to reflect that DCJS will just be using in the following subjects, not an over-inclusive list that they have to come up with everything.
So I'd move that line amendment.
Without objection, that a line amendment is adopted.
Thank you, Mr. Chairman. This bill does a few things. House Bill 5109, it adds specific subject areas for training in the police academies. Some of those things include awareness of systemic and individual racism, bias-based profiling, both real and perceived, interactions with those with serious mental illness, substance abuse, and developmental disabilities. They would learn de-escalation techniques and training in the lawful use of force, when to use deadly force, in what circumstances to which do it. It also adds specific subject areas for in-service training. So think of yourself as an attorney. You have to go to law school and take the bar exam. But we also have to do CLE credits as well every single year. Law enforcement officers also have to do, I believe it's 40 hours every 2 years. And so in-service training would allow them to have a refresher on these topic areas while in-service training. The second thing that the bill does is requires, and this is really the meat of the bill, it requires all Virginia academies to adopt curriculum developed by DCJS. This establishes and creates the department as the source of a uniform curriculum. And any type of alternative curriculum must be approved by the department. So basically that a law enforcement officer in Arlington gets the same level, same minimum standard level of curriculum as a law enforcement officer in Campbell County or Isle of Wight. It also requires law enforcement officers to undergo a psychological exam prior to employment. So that in a nutshell is what the bill does. And Mr. Chairman, I'm happy to take any questions from the members of the committee. I do have the advantage of knowing who's in the queue to speak. And I believe Eric Smith is the only person that's in the queue. So if you want to invite him in.
Thank you, Mr. Chair. I believe looking at the queue that I'm in, there may be a few others that are lined up to speak on the bill. Again, Eric Smith with DCJS, just like to state that while the administration has no official position on this bill at this time, I would note that if the bill is passed, there would be a necessary a budget amendment because there would be an additional fiscal impact that would come from some of the new requirements that would be placed upon the agency with this bill, especially as it comes to writing the uniform curriculum and then the review and audit process for that. Thank you.
The other speaker is Michael Harvey. Please unmute your line, Mr. Harvey.
Good afternoon, Chairman. Can you hear me?
Can hear you great. Thank you. Welcome.
Excellent. Thank you, Chairman. Thank you, committee, for all your hard work today. I know it's been a long day, so I'll try to stay brief. My name is Mike Harvey, and I'm the executive director of the Rappahannock Regional Criminal Justice Academy in Fredericksburg, Virginia. And I've been a local law enforcement officer here in Virginia for 24 years. I would like to say that I am in full support of the uniform curriculum and lesson plans as proposed by this. But I will also say that it's going to be a very heavy lift for DCJS. So as the committee looks at this, I hope you take that into consideration and appropriately fund DCJS so that they can roll this out. As an academy director, I'm only one of 38 across the state, and I will say that this is not going to be supported by all of the academies. And so there will be quite possibly some pushback to that. As far as the advanced training, the uniform curriculum for the entry level and the in-service, I fully support. But when we get to advanced training, I just caution the committee that there are so many different types of training across the state where we may not be able to truly roll that out from a centralized point because it may not apply from one section of the state to the other. And the lift for the entry level and in-service criteria are going to be a lot. And so I don't know about adding that third component of the advanced training is truly going to be effective for what the community wants to see. Thank you.
Thank you. I believe I see Delegate Wilt has his hand raised on the system. Delegate Wilt.
Thank you, Mr. Chairman. I was a question for the patron or possibly Mr. Smith. But my question is, the department, forgive me for not remembering an exact timeline, but I think it's been the past year or so that they have been working on this very thing, training standards and so forth. And I want to say that that's due to roll out, sometime maybe in the next year. So, but what are the things that are included in this legislation that aren't already? I thought that were already being covered in the update that the department's doing.
Well, I can respond to part of that, and then Eric can also chime in as well. The meat of what this bill does is it establishes the department, DCJS, as the curriculum standard bearer. In other words, we have academies doing at all different levels, doing different things. And I want to make sure that there's some standard development body where all these different curriculum, the minimum standard needs to be blessed. So that in your jurisdiction, your law enforcement officers are trained in specific criteria, minimum level criteria are the exact same standards that are being trained in my neck of the woods in Arlington County. And so we're developing a standard. So that's really the guts of what the bill does. What the bill also does is it specifically lays out things, especially in light of the violence that we've seen lately, specifically the different awareness of systemic and individual racism, the bias-based profiling, interactions with those with serious mental illness. That's sort of a not crisis intervention training, but something like that. De-escalation techniques. So it specifically speaks to those items in what we're doing. And I think Eric could speak to where they are in the development of that different curriculum. It might be complementary to what they're already doing. It might be additional to what they're already doing.
Thank you, Mr. Chair. I would say it is mostly complementary to what we are already doing. Things such as de-escalation, the bias-based policing, working with individuals with disabilities, mental health needs, and obviously use of force are already things that were in the existing entry-level training standards for law enforcement. As Mr. Harvey could probably tell you in great detail, as he is also a member of our curriculum review committee that has been working on those standards, those topics have been significantly addressed and probably beefed up from where they were. Several of those topics, I know bias-based policing is one that jumps to mind directly, has been removed from being sort of a subtopic or a performance outcome to being its own standalone performance outcome. So it's its own topic to be taught rather than just taught as part of something else. or at least that's what the recommendation will be with the revised standards. Again, I would say that a lot of these are complementary to what is going on with the ongoing review process.
Thank you. Let me see. I don't think I see any other hands raised. So I'll give the patron one last final word if he wants it. Otherwise, the committee operates by motion.
Move to report, Mr. Chairman.
Second.
We don't have a letter from the appropriations, and I did communicate with the Speaker's office, and I did not hear that it should go to appropriations. But out of an abundance of caution, Eric, you said that it could have the psychological portion, I believe, could have a fist to it, and so I just wanted to make sure we're extremely cautious in what we're doing here. So I would recommend that we, if the amendment is report and refer to appropriations as amended.
So moved.
It's been moved and properly seconded that we report House Bill 5109 and refer it to appropriations. Members can vote on their electronic voting machines.
Delegate Ferris, Delegate Campbell. Mr. Chair, all members have voted.
Thank you, Madam Clerk. Bills reported and referred by a vote of 21 yeas and 1 abstention.
Great. Thank you, Mr. Chairman. Thanks to everyone for their indulgence and staying with us this entire time. The committee, unless there's anything else before we adjourn, the committee stands adjourned.